Yes. Division bench item 1 to 5.
Yeah, please, Your Lordship. My friend is arguing the case of Ajay Vasudhara. He was the case number 3. And on the last date, Lordship, we were on the aspect of sanction. If I may take the Lordship to document 60, page 684 of volume 3.
Somebody has given this list.
I give the
Please write for whom you are giving. Otherwise, I will not know. Yes.
Lordship, may be pleased to take volume 3 of the paper book, page 684.
Volume 3. Cite volume. Cite volume क्या है? यहाँ लिखा. Yes.
Lordship, 684, Lordship as well.
684.
684.
Yes.
I take your Lordship to 685. Paragraph 6.
Yes.
And whereas the authority, after being satisfied with the material available on record and facts and circumstances stated therein, has recommended for sanction for prosecution against the above mentioned 4 accused under the relevant sections of Unlawful Activities Prevention Act 67 as under Lordship, let's see 3. 3 is Ajay Vasudhara.
Okay.
Section 18 and 20.
Yes.
And next paragraph. And whereas the central government, after carefully examining the material placed on record and recommendation of the authority, satisfied that the prima facie case is made out against the accused person under the relevant sections of the Unlawful Activities Prevention Act, the Indian Penal Code, the Arms Act, and the Explosive Substances Act, as mentioned above. Now, therefore, the central government hereby accords sanction for prosecution under Section 196 of the CRPC and Section 45(1) of the Unlawful Activities Prevention Act 1967, as amended in 2008, for prosecuting the accused persons in the crime so and so, for taking cognizance of the said offences by a court of competent jurisdiction as under. Now, here also three sections 120B, 121, 121A, 123 of the IPC, section 18 and 20 of the UAP Act. However, Lordship, the trial court has convicted the accused number 3 under section 121, 302, 34, 307 IPC and 16(1)A, 18 and 20 of the UAP Act. Now the question which falls for your Lordship's consideration at this stage, 18 and 20 Lordship already sanction has been accorded. Whether court could have proceeded to convict him under section 16(1)A.
Yes.
Now, Lordship, so far as Lordship interpretation of a statute is concerned, Lordship, the harsher the act, the more strictly Lordship has to construe the provisions.
Yes, that is the law.
That Lordship now. If I may take your,
Oh, please continue.
if I may take your Lordship to section 45 of the
In the digital world, we are doing multitasking.
that is his Lordship was writing something.
No, that's what I said. I'm multitasking. Please proceed.
Section 45 of the UAP Act
UAPA, Unlawful Activities Prevention. Unlawful U. Yes.
May I read it, Lordship? No court shall take cognizance of any offence under Chapter 3 without the previous sanction of the central government or any officer authorized by the central government in this behalf. We are concerned with 45(1) Roman. Under chapters 4 and 6, without the previous sanction of the government, central government, or as the case may be, the state government, and if such offense is committed against the government of a foreign country without the previous sanction of the central government. We'll leave apart subsection 2 for the moment. Now, Lordship, Lordship, I have tried to make some research on the point of sanction so far as this act is concerned. Lordship, taking cue from our judgment of the Honorable Supreme Court in the case of Nanjappa versus State of Karnataka, which was case of Lordship 2015. Here, Lordship, it relates to the
what is the citation?
Lordship, 2015-14 SCC 186.
2000?
2015-14 SCC 186. Here the Honorable Court, Supreme Court was dealing with the provision of Section 19 of the Prevention of Corruption Act. Now, so far as the opening sentence of the Prevention of Corruption Act, Lordship, I'm just reading out for your Lordship's convenience. 19. Previous sanction necessary for prosecution. No court shall take cognizance of any offense punishable under Section 7, 11, 13, and 15 alleged to have been committed by a public servant except with the previous sanction, save as otherwise provided in the Lokpal and Lokayukta Act. Now, though it starts with a negative note, the Supreme Court has held in this case, Lordship, that the legal position regarding the importance of sanction under Section 19 of the Prevention of Corruption Act is thus too clear and admit equivocation. The statute forbids taking of cognizance by the court against the public servant except with the previous sanction of an authority competent to grant such sanction in terms of clauses A, B, C, and B and C to Section 19(1). Now, when the position as of now is, when the special act expressly bars a prosecution without a sanction, the court has held that the prosecution would be held non-est in law.
Please elaborate. Just please elaborate. I'm missing it.
Yes, Lordship. When unlike the CRPC where there's a provision, Lordship, there are cases where the court has held that when the trial is going on, even at that point of time, a sanction can be had. There are, but when it comes to a special act, like the case we are dealing at present, Lordship,
Yes.
the Supreme Court as of now has held that without a sanction, the prosecution will be non-est.
Because of the non-obstant clause,
Yes.
no court shall.
Yes, no court shall. Same thing has been reiterated, Lordship. This is with regard to that Prevention of Corruption Act. There is another case.
Just a moment. You are citing 2015-14 SCC.
Yes, Lordship. I'll just check up.
15-14 SCC 183.
186.
86. Oh, okay.
That is Nanjappa versus
No, now I got it.
State of Karnataka.
Hmm.
If your Lordship is having Supreme today, paragraph 50. 15-16 Lordships. I'll just read out Lordship paragraph 16 also.
15-15.
15, I have read out the relevant portion. The question regarding the validity of such sanction can be raised at any stage of the proceeding. The competence of the court trying the accused so much depends upon the existence of a valid sanction. In case the sanction is found to be invalidated, the court can discharge the accused, relegating the parties to a stage where the competent authority may grant a fresh sanction for prosecution in accordance with law. If the trial court proceeds despite the invalidity attached to the sanction order, the same shall be deemed to be non-est in the eyes of law and shall not forbid for a second trial. If the court claims that there was no sanction, it can relegate it back, take a sanction, then proceed. Now, I take your Lordship to a case whether UAP Act was dealt with. I do not have the citation, but I will give your lordship the party name. Swaha Fasal versus Union of India.
Oh, Khwaja, that is 2020, I think. Khwaja Faisal,
Yes.
FAISAL.
Yes. FASL.
FASAL.
FASL.
Huh.
FASL versus Union of India.
Tawa Fasal.
Yes.
Yes, yes.
In my lordship, when the lordship it starts at paragraph 21, lordship, I'll give a print of while dealing with the paragraph 21 in my lordship.
Just a moment.
21 and 22.
Twenty-one, 22.
Lordship, the paragraphs may differ, lordship. I'll give a printout of this, lordship.
It's okay. Just let me see if it can match.
It starts with under subsection
Under
1
subsection 1.
Yes, yes.
Yes.
Under subsection 1 of section 45 of the 1967 Act, the court is not empowered to take cognizance of any offense under chapters 4 and 6 without the previous sanction of the central government. Procedure for obtaining sanction has been laid down in subsection 2 of section 45, which reads thus: sanction for prosecution under subsection 1 shall be given within such time as may be prescribed only after considering the report of such authority appointed by the central government, or as the case may be, the state government, which shall make an independent review of the evidence gathered in the course of investigation and make a recommendation within such time as may be prescribed by the central government, or as the case may be, the state government. Next paragraph is important. The order of sanction dated 18th April 2020 is a part of the charge sheet which is placed on record of these appeals. Paragraph 2 and 3 of the order of sanction show that though the offense was registered under sections 20, 38 and 39 of the 1967 Act by a letter dated 13th April 2020, NIA did not seek sanction for prosecuting any of the three accused for the offense punishable under section 20. Sanction was sought to prosecute the accused numbers 1 and 2 for the offenses punishable under section 38 and 39. In addition, a sanction was sought to prosecute the accused number 2 under section 13. Paragraph 4 of the order refers to the authority appointed by the central government under subsection 2 of section 45, consisting of a retired judge of a high court and a retired law secretary, as well as a report submitted by the said authority. Paragraph 6 of the said order records prima facie satisfaction of the central government that a case is made out against the accused under the provisions of the Act of 1967 as mentioned in letter dated 13th April 2020. Thus, Lordship will just mark this sentence. Thus, as of today, sanction under subsection 1 of section 45 has not been accorded for prosecuting the accused for an offense punishable under section 20 of the 1967 Act of 1967. Therefore, as of today, the special court under NIA cannot take cognizance of the offense punishable under section 20. Therefore, deciding the issue of a prima facie case contemplated under subsection 5, this is not material, Lordship. Since the relevant section 20 was not there, therefore the court would not have considered, Lordship. I would not take a contrary, because even recently, Lordship, a case of Mahesh Kariman Tirki, where this development called Sai Baba was also a Maharashtra. There,
What is the name of the parties?
it is Lordship Mahesh Kariman Tirki.
Second word, how do you spell it?
K-A-R-I-M-A-N-T-I-R-K-I.
T-I-R.
T-I-R-K-I.
T-I.
Versus State of Maharashtra. This particular case, Lordship, is a case from the Bombay High Court, which was taken in appeal before the Honorable Supreme Court. This, your Lordship will find reported in 2022 all MR criminal 4428.
You're referring to Bombay.
Bombay. This
This is Bombay judgment.
This is Bombay.
Because Bombay has been taken to Supreme Court. Supreme Court judges of the other two judgments of Mahesh Kadiman Tirki. One is 15/10/2022 and one is 19/4/2023.
I will be referring to 19/4/23. I'll be referring to 19/4/23.
19/4. Okay. So should I begin with Bombay or I go to Supreme Court directly?
Lordship,
Bombay first.
Not first Bombay, I will just. Here also, Lordship, while summing up,
Paragraph.
it's the last paragraph, 9 conclusions. Conclusions are, I will just read the first subparagraph. In view of the findings recorded by us, we hold that the proceedings in sessions trial so and so are null and void in the absence of a valid sanction under section 40(5)(1) of the UAP Act, and the common judgment impugned is liable to be set aside. So this was taken by the state to the Honorable Supreme Court, and the Supreme Court, by its order dated 19 April 23. I'm reading the 6th paragraph. In view of the above.
Just a moment.
This is 2023 Live Law Supreme Court 438.
Paragraph.
Paragraph 6.
Oh, small.
It starts with in view of.
Yes.
In view of the above broad consensus between the respective parties recorded herein above, and without further entering into the merits of the case and or expressing anything on merits in favor of either of the parties, with the consent of the learned counsel for the respective parties, we set aside the impugned judgment and order passed by the High Court in Criminal Appeal 136/37 of 2015. One 2017. I'm sorry, Lordship. The matters are remitted back to the High Court to decide the said appeals afresh in accordance with law and on its own merits, including the question of sanction. It will be open for the state to contend that once the accused are convicted after conclusion of the trial, the validity of sanction and or no sanction in case of one of the accused cannot be gone into, and or the same would become insignificant, and as and when such issues are raised, the same be considered by the High Court in accordance with law and on its own merits. It will be open to the accused, open for the accused to counter the same. We have also specifically observed that all the contentions and the defenses which may be available to the respective parties are kept open to be considered by the High Court in accordance with law and on its own merits, and on the above and on the basis of the evidence which is already on record before the learned trial court. Now, Lordship, insofar as sanction is concerned, Lordship, the Supreme Court does not take any different step. It has already been sent back to the Honorable High Court. And as on date, Lordship, the judgment of Fasal, that in my humble submission would stand because there was no sanction. Therefore, the court could not have proceeded, Lordship, until something new comes up, Lordship. And insofar as, Lordship, here.
Then perhaps you should have referred to the second judgment of Supreme Court, 2013, sorry, that 2022 10 SCC 207.
Lordship.
That would have been a better proposition. Just put up that 2022 10 SCC 207. Yes. Para 1 onwards. It was. So after this, the 2023 judgment has come, where on consensus it has been remanded.
Yes,
Consensus is something we may not be empowered to do.
that, yes. So, but one aspect of the matter which I would like to raise before you also. So far, the question of sanction is concerned, also, it was never agitated further.
But that's why I refer to the second judgment.
Otherwise, Lordship,
Because here section 465 was invoked. You read 465, then you will come to know.
failure of justice. Now, now, my submission before your Lordship is even if section 16 goes, for there not being a sanction, it will not, Lordship, materially affect the case in other aspects, because here, Lordship, if you
No, it may alter the situation
Lordship,
because till now what Ms. Chaudhary has been,
signature,
NNP Chaudhary has been submitting was that the eyewitnesses, the versions are different, and it would be only 302. So if UAP goes, perhaps death reference would be affected. So the sentence of death, that may have some bearing on that.
Lordship, for a moment, if I may, section 16. Lordship, please see section 16. Yes, it is 16(1)(a) with death, imprisonment for life. But Lordship, 302.
Death sentence is 302.
302. Now, if we see 302.
Okay, would not have much bearing.
So my submission will be, Lordship, even if we discard for having no sanction, 16(1)(a), yet 302 remains, Lordship. Under which he can be punished with death. So that would be my submission, Lordship. Sanction, Lordship, as on date, Lordship, it is held that sanction is necessary.
Yes, Mr. Chaudhary.
What's your?
For convenience, we'll call you one and we'll be called two.
Yes, senior.
My friend has finally submitted before your lordship. Section 16 section is required. With that one, I strengthened so that one does not
I can't do so.
yes. Some music like this. There are 23, my lord.
Yeah, just Yes, paragraph.
Para 23, my lord. May I read, my lord? Before
Yes.
going to that, my lord, I have to submission, my lord. If the sanction was not granted, my lord, then it is the violation of Article 21 of the Constitution of India. If it is violation of the Article 21 of the Constitution of India, my lord, the CRPC section, my lord, cannot override the Article 21 of the Indian Constitution. My lord. That is my humble submission before your lordship, my lord. I start this judgment. Paragraph 23. We are opinion that the provision of sanction is mandatory and the stipulation of time also is mandatory and sacrosanct. We have noticed the legislative history of the enactment and the provision of sanction incorporated thereunder to take cognizance of charges based on activities level and defined as unlawful, terrorist, and disruptive. It has been found that sanction under UAP Act granted after 6 months from the date of receipt of recommendation authority is not a valid sanction. It is also stated that sanction order merely speak of the government after careful examination of the record, investigation in detail, being fully satisfied of the accused, having committed an offence punishable under section 20 and 30 of the UAP Act. The sanction order merely referred to the record of the investigation in the respective crime. The letter of the state police chief and recommendation of the authority considered under section 45 of the UAPA Act. It has been emphasized that 45(2) of the UAP Act make it mandatory for the authority to make an independent review of the evidence gathered in course of investigation, make a recommendation within the such time prescribed to the appropriate government. This does not absolve the appropriate government for applying its mind, since otherwise there is no requirement for further sanction from the appropriate government. We have seen from the precedents that sanction for the prosecution is solemn and sacrosanct act which required the sanctioning authority to look at the facts and arrive to the satisfaction of requirement of a prosecution. It was held that despite of the letter of the DSP being exhaustive, the government ought to have verified that all allegations as stated by the DSP are gone out from the record. In the case of UAPA, despite of the independent review made by the authority constituted under section 45, the government has to arrive to the satisfaction without merely adopting the recommendation of the authority. The government is to be emphasized has no obligation to act in accordance with the recommendation of the authority. The sanction of the government and not the authority, and the recommendation of the authority only aid or assist the government in arriving at the satisfaction. In the present case, there is no such application of mind discernible, but for the reference to the recommendation of the authority and the laconic statement of the government, the details have been verified on which satisfaction is recorded as to the offence having been committed by the accused, for which prosecution has to be initiated. We find the sanction order of the UAPA to be not brought on in time, as the statutory mandated preferred any application of both the vitiating the cognizance taken by the special court. And your lordship come, my lord, paragraph 27, my lord. Page 32, my lord. All the sanction order invoke power under the UAPA, as rightly pointed out by the landed government pleader Maila, because power UAPA is alone invoked. If the order discloses considered material for the purpose of granting 197, definitely the sanction order can be availed. Cognizance to be held, especially when the grant of UAPA and 196, the same authority had the government. In all the revision petitions are sanctioned in order after recording the satisfaction of the accused committed offence, UAPA based beside offence punishable under relevant sanction of IPC for which they should be prosecuted. The satisfaction or revealed from the order does not refer to the precise provision under IPC. It is more iconic than satisfaction under section 1 referred to chapter 5, 153A, 15295A, 13, which is alleged from chapter. The offence falling under chapter 6, offence against the state, and the offence are respectively promoting enmity between the defendant group of thereunder during imputation, accession, and deliberation malicious act intended outrage religious, feeling, and mischief religion. Those related public mischief. 352 under subsection 1(3). Offense so to call out for the purpose of mandating a requirement of sanction from the appropriate government are those which could be, by its very initiation, result of allegation, violation of fundamental rights. The very offense, though engrafted the IPC, whether the act, complaint, fall under the provision is a matter of perception, regulate the individual experience. It could be result of drastic action and punitive measure being taken against the alleged perpetrators, which could later be classified in malicious ill motive. It is avoid such consequent well-meaning citizen even when that Parliament very consciously brought into the requirement of sanction. That is important. The procedure for a recommendation from the authority constitutes a further sanction from the appropriate government. Ensure one objective consideration of the requirement to prosecute. The various offences vary in the content, essence, without even a mention to a complaint of the offence alleged or even precise provision. The government has made a cryptic statement which falls short of satisfaction either with due application of mind. The sanction under both UAP and IPC have to be found invalid, not eligible in special court to take cognizance. Can I say?
So, Mr. Akadi Chaudhary, this what is the notification with regard to that time for granting sanction under 45(2)? I think somewhere we read 45 days. In the previous judgment we were reading, it was said 48 days.
Worship will see unlawful activities prevention, recommendation and sanction for prosecution rules 2008.
Oh, achha.
Three.
Within 7 working days. Within 7 working days.
Yes, yes. There are 28 pilots. I have 26. The sanction accorded to prosecute the petitioner for reason of the same have not been issued within the stipulated in the UAPA and the rules of 2008 is vitiated. The statutory mandate of the time of having not complied with, the special court cannot take cognizance of the offence under section 20 and 38 of the UAP. There is also complete absence of application of mine under 196(1) of the CRPC. Again, there is no application of mine to the in the satisfaction. Evidence order into hence the cognizance taken offence under 124 IPC has also failed. The cognizance taken session code IPC are set aside. Order pass including criminal division petition are set aside. I show this judgment, my lord, because my lord 16 has already been argued, my lord. 18 and 20, my lord, whether it was taken on time, my lord, that is, my lord, is question, my lord. In respect of 18, 20. Because I was convicted on 302 and 307, my lord. 120B, 121, my lord. 120B is not available in respect of my case, my lord. If 18 and 20 goes for sanction manner, then only 302. And I want to show some judgment of the appeals court manner in respect of PC Act manner. Only I have given the book list. Onil Kumar versus manner others MK Ayappa. Citation is 2013 10 SSC 705. Sorry, 2013 10 SSC. Sorry, 13 10 SSC 705.
705.
705. Onil Kumar and others versus MK Ayappa. This judgment was followed in many cases in our High Court. There are 5 minor tasks. Yeah,
Is it just on one?
Para 5 minor. I want to show that sanction point I can be taken even pre-cognizant stage and post-cognizant stage also. Minor. At any point of time, I can take the sanction. Para 5 minor. The High Court, after hearing the party, took the view that special judge could not have taken notice of private complaint unless the same was accompanied by a sanction order, irrespective whether the court was acting at the pre-cognizant stage or post-cognizant stage. If the complainant pertained to a public servant who is alleged to have committed in discharge of duty, the High Court therefore passed the order passed special judge the complaint filed by the petitioner agreed by the same already stated. And this complainant has come up with the appeal. There are 15 miles. The judgment have it also there are 15. Please 712. The judgment referred to herein above clearly indicate that word cognizance has a very wider connotation. It is not merely confined the stage of taking cognizance of the offense. When a special could refer a complaint of the investigation 156, obviously he has not taken cognizance of offense. Therefore, it is a pre-cognizance stage that cannot be equated with the post-cognizance stage. When a special does take cognizance of the offense presented under section 200 CRPC, step to be to follow 202. Consequently, special is referring a case investigation under section 156T is a pre-cognizance stage. Then my love finding come my love page 21 my love. Finding of my love. Yeah. The learned counsel for the appearing of the era 21 page 713.
Yes.
The learned counsel appearing for the appellant raised the contention of the requirement of sanctions is only procedural in nature. Hence, the directory, else 19.3 would be rendered obvious.
Yes.
We find it difficult to
No, please proceed.
we find it difficult to accept the contention. Subsection 3 of section 19 has an object to achieve, which applied in circumstances where special judge already rendered finding, sentence, or order. Where a special judge has already rendered a finding, sentence, or order, in such a way it shall not be reversed altered by the court appeal confirmation revision on the ground of absence of sanction. That does not mean that requirement of sanction is not a mandatory requirement. Once it is noticed that there is no previous sanction as already indicated, various judgment referred herein above, magistrate cannot order investigation against the public servant when under 156. The above legal position is already Subramaniam Sami. For that, Army headquarters does in view the law of issue of sanction can be summarized to the effect the question of sanction is a paramount importance for protecting the public servant who has acted in good faith while a duty in order to public servant not sanction. The required sanction, the court proceed against the public servant without sanction. The public servant has a right to raise issue jurisdiction and action may be rendered as void ab initio. We have viewed that laid down in the court. Present case, we find no other. To following this kind of one judgment has been followed. I will not read the judgment. Osama Barma Minor in our High Court. Following this only tomorrow. 2015 4 SSC 533. 2015 4 GLT 533. Osama Barma versus State of Assam and Assam. Following this principle, my lord, the proceeding has been quashed. I am not reading the judgment. It is a single judgment, my lord. Para, my lord, is my lord 4, 7, 9, and 12, my lord. Now I want to read a judgment, my lord. The apex code, my lord. 1986 4 SSC 326. Para 10. '86 4 SSC 326. A.K. Roy versus State of Punjab.
Yeah.
1986 4 SSC 326. A.K. Roy versus State of Punjab.
4 SCC page.
Page 326. Para 10, my lord.
Yes.
I read that paragraph. A careful analysis of language of section 21 of the Act means Food Adulteration Act. Clearly shows inhibit institution, prosecution, and offense under Act except unfulfilled one or other two conditions. Either the prosecution must institute the central government or the state government. A person authorized in their behalf of the central government, state government, or the prosecution should be instituted with written consent or the four specified category authorities. If either of these two conditions is satisfied, there will be sufficient authority for the institution of such prosecution for offense under the Act. The provision contained section 20, subsection 1 Act does not contemplate an institution of prosecution by any person other than those designated. That is important. Because in this case, that who has given sanction, yes, or one undersecretary has passed an order. And there is no delegated power under section 45 of the UAP Act. No delegation power. A learned friend showed that particular case. Once rules has been there, undersecretary can exercise the power on behalf of the president, president of India. But in this case, they have to give the sanctioning authority give this. I am reading thereafter. That's 21 for the prosecution instituted central government or the state government or person. The use of negative or section and no prosecution for an offense under the Act. The line has been started negatively. Shall be instituted except it or with the written consent of it. Plainly make the requirement of section imperative. That conclusion of our must necessarily follow from the well-known rule construction interference be drawn from the negative language used in the statute used by credits of the on statute law. Edition 263 on parts language. That is, if the requirement of a statute which prescribes the manner in which something is to be done expressed in negative language, that is to say, if the statute enact, it shall be done in such manner, in no other manner. That is important. It has been law laid down that those requirements in all cases absolute and that neglect attend to them invalid and whole proceeding. I saw because if you also go to the order of the person who has produced the sanction order, as you also complete 16, that part will be higher, sanction paste, position of PW 14, page 43. And because we have discussed the sanction point, I also soon on this points. Today I have appeared before the court on
Yes.
this 43.
No, Mr. Roy is there. I just acknowledge his presence.
It's my privilege.
Today I have appeared before the court on receipt of someone from the court. I have been working as Undersecretary, Government of India.
That is at which page of the paper book?
43, volume 1.
Volume 1.
Yes. Today I appeared before going. Yes, madam, I am reading that. Thereafter I go to the that sanction letter. Today I have appeared before the court on receipt of the summons from the court. I have been working as an Undersecretary, Government of India, Ministry of Home Affairs, New Delhi since 2012. I issued the order dated 27/12/2014 on behalf of the Government of India for transferring the 4 cases, including 731/2000 registered at Thikejali PS onto the NIA in accordance with Section 64 of the NIA, seeking approval of the Union Home Ministry. Exhibit 26(1) is the said order. I will come this exhibit on later, madam. I received the investigation report along with all enclosure witnesses 13/7/2015. I referred the aforesaid report along with all enclosure to the authority constituted under Section 45(2) of UAP Act. 1670. To that point of time, my love, 1820 is also not there, my love. When that, my love, 16 is not there. Sorry, 16 is not there. And Justice K. Ramaswamy, K.D. Singh, formal lawsuit government for independent review of the investigation, telling him from my memory. Huh? Oh, sorry, man. One page is missing full and making it too much to the other. Take a page the worst to mean what to qualify. No, I think in the testimony 3 maras report. And report and making recommendation. The authority submitted recommendation to the ministry and sanction of the prosecution against 4 accused persons: Sanju Bordole, 120B, 121, Ajay Vasumotari is concerned, my love, 120B, 121, 121A, and 130, and section 18 and 20 of the his issued perusal of document, application of with the approval of Home Secretary, with the approval of the Union Home Secretary, 27/2000 in case number was registered by NIA Guwahati branch. Your approval has been given by the Union Home Secretary. Under Secretary has been appeared. Registered and the sanction order 3 pages, exhibit 21 signature.
Lord, I'm sorry to share. In this case, I am also appearing for one of the accused who has been sentenced today. But I am having severe throat infection, so I'll ask for a little accommodation for some time.
No, this is since this
This matter, we will carry on with this matter. It's not going to end today.
Yes. So I think I will recover soon. But,
No, this is it doesn't concern your what do you call appellant. It's of Ajay Vasumotari.
I'm observing it and looking it online. So I'm aware of what your lordship's queries are there. As soon as the other counsel will finish, I'll start. I'm obliged.
My email in connection with the sanction of the 3/27/1. I prepared the sanction of the sign on behalf of the President as an authorized officer. My lord, there's some typographical error in the aforesaid exhibit, the last sentence where authority was typed as 27/23/12/2004. Here we say there is a typography in the unlawful activity recommendation. There is mention of authority. There is mention of authority. It is not mentioned section 12 on which date the authority was constituted by the central government. I have not mentioned in notification number by which the authority was constituted by the central government. Notification number has not been mentioned by them. In exhibit 27, I have not mentioned on the date which investigation report along with the enclosure was received by the authority constituted by the government of India. I have not mentioned exhibit 27 as on date I received back the recommendation of the aforesaid authority. There is also no document right now available in case record to show that as on which the authority received investigation report sent back to the recorder. However, I volunteered to clarify that there is no document right now available in case record to show as on which date the authority received the investigation report and sent back their recommendation. That is not available now. That line is very much important. However, I volunteered to clarify report which referred to the authority on 13 July 2015 and report of the received 16 July and understand issued sanction for the vision 20 July, which is within scheduled as per the aforesaid rule. He is submitting from the memory, my lord. That record that is not available when it was sent, my lord.
No, that question, you see, we can't have an answer to that. You see, what has happened is that the under 45(2), it is the central government who has taken who has given a sanction.
Yes, ma'am.
In this unlawful activities prevention recommendation and sanction prosecution rules, they in the definition clause it refers to an authority,
Yes, ma'am.
but that authority is not a requirement under section 4. It says the central government or the state government, as the case may be.
Yes, ma'am.
So if the department takes a call, you can't even if you ask any question to the witness, doesn't take away the what do you call the sanction which is otherwise valid. You see, this act does not say that it must be given by the authority. It gives liberty to the state government.
Yes, ma'am. Yes,
And
correct.
here the signature is by order of in the name of the President of India.
Yes, ma'am.
So that can't be questioned.
I am coming with my lord on that point. Before that, you also can be 7 days, my lord. There is no document right now available in the case record to show and who is that authority received the investigation report, send back their recommendation. However, I volunteer to say record that is not available. Nothing is available, my lord. He from memory, how can he submit as a my lord?
No, you never asked him. You see, the witness was never summoned to bring record. You just cross witness without a notice of what you call the requirement of bringing a document. You see, number one, you did not raise an objection in the when you got the documents saying that the letter when the records were received by the central government must be produced. That was never your stand. Now, in the cross examination, I have asked anything to anyone. Will that become what you call? Will that prove lack of documents?
My humble submission is that when the charge sheet has been submitted, every document is produced before the court.
No, I understand, but you
It
see,
is
you
the
never.
duty of the prosecution to show him, my lord, that this is the
It's
document.
okay,
Yes, ma'am.
but still, when you are raising this point, is it not required that you see what do you call the document? The state or the court was never put to notice that the document itself is not available, and therefore sanction should not be taken. Cognizance of the sanction could not be taken. You see, that was never raised. So in the cross-examination, you have to demonstrate that this question in the cross-examination will initiate the sanction. That will be for you to demonstrate.
Yes, my lord. At least in cross part, this part.
No, it has come, that is okay, but I'm just trying to understand your argument,
Yes, sir.
because if that be so, let us take in any suit the say specific performance of contract.
Yes, ma'am.
Somebody files a suit for specific performance, so and so. In the cross-examination, if you ask him, well, did you file the copy of Jamabandi? He said no, because you'll have to show that it was otherwise relevant.
Yes, ma'am.
I'm giving an example which may be very horrible,
Yes, ma'am.
but it's just to understand the argument.
My humble
The-
submission before your lordship is that, my lord. There is a difference, my lord, between my lord, Article 21 has been violated and other petitions.
No, that point we have taken note of.
1980 SC 1980, my lord. That para 4 English law has been discussed because I am doing very NSA case earlier with my senior. My lord. And para 5 has said if Article 21 has been violated once you have shown, then it is not need to show any pleading and other things that why your right has been not been violated, you have not taken this pleading in your petition. AR 1980 SC 1980 para 5. Because in
Just a minute, let us go through it. Just a minute.
para 5. It should be solution.
Hmm?
It should be solution. AR
Just a
1980
minute.
SC 1980.
AR 19
1980 SC 1980. Paragraph 5, your lordship.
1983.
3. Para 5 is the Indian law, my lord, in this to Article 21. 1980 SC 1980 may I read another paragraph?
Yes.
The practice make a departure. I am not reading English law para 4 by law or Indian law. The practice make a departure from that obtaining in England, where observance of the strict rule of pleading insisted upon even a case where application for a rate of habeas corpus, but it has been adopted by this court with a view peculiar socio-economic condition prevailing in the country, where the large masses of the people are poor, illiterate, ignorant. Assess court is not easy on account of lack of financial resource. It would be most unreasonable to insist that the petitioner should be set out clearly and specifically the ground on which he challenged the order of detention, make out a prima facie case in support of those grounds before a rule issued, and is hold that detaining authorities should not be liable to do anything more than just meet specific ground to challenge put forward by the petitioner in this petition. The burden showing the detention in accordance with the procedure established by law has been placed by the court on detaining authority. It is the prosecution duty. Because Article 21 of the Constitution provides this clear explicit term, no one shall be deprived of his life or personal liberty except in accordance with the procedure by the law. The constitutional right of life and personal liberty is placed such a high pedestal by the court that it has always insisted whenever there is a deprivation of the authority responsible for such must satisfy the court that it has acted in accordance with law. This is an area where the court has to most strict and scrupulous in ensuring observation with requirement of the law. Even where requirement is breached and the slightest measure, the court has not hesitated to strike down the order of detention or to direct the release of the detainee, even though the detention may have been till the breach occurred. The court has always been personal liberty as the most precious possession of mankind, refused to tolerate illegal detention regardless of social and moral regulation.
Come to the end.
And 11, para 11, you will also read.
To both Mr. Chaudhary, we'll propose to rise at 12.
Yes, sir.
Because there is single bench.
Yes, sir.
We'll fix some other day for continuation of hearing. Yes.
Yes, sir. That is why I am submitting that matter. Next line, matter. It is true the aforesaid date are not mentioned in the document which I exhibited today, but telling this from the memory, from my memory. Exhibit 27 is the sanction order. The detail of the material collected against accused have not been mentioned. What material that was not mentioned? Those this will be found statement of the witnesses. Document filed by IO. I deny the suggestion of the authority did not communicate their recommendation within the prescribed time of 7 working days from the date of receipt of the message. We take the suggestion, madam. I deny the suggestion the sanction order was not issued following law laid down rule procedure. I deny the suggestion that central government did not issue sanction order within 7 days after receipt of the recommendation of the authority. It is not a fact that there is no document to show that central government did not accord sanction against the under section 196 of the bill. It is correct that I am not the sanctioning authority. The witness volunteers I am authorized to issue sanction order in accordance with authentication order rule 2002. Rule 2002 says, my lord, subject to correction, on behalf of the President of India, my lord, the power can be exercised by the Secretary. Secretary, Deputy Secretary. Can be issued by the Secretary. It is, I think, Article 161 and 162. It is true that detailed recommendation authority is not appear. My humble submission before the is that sanctioning is someone different, man, not president of India. Man. Yeah, interesting thing is, man.
No. Every department works under for the purpose of Article 162 to
Yes,
the
162,
to the President of India.
President of India. Man.
Under the name of
Sanction-
President of India.
Sanctioning authority is different, man. If the sanctioning authority has come before
Section
of
4
course,
doesn't
my
say
lord,
so.
because one of the judge, my lord, at least, my lord, their secretary should come before the.
No, section, you see, if the order is passed by the secretary,
Yes, sir.
still it is the, still for the purpose of Article 162, it is under the authority of the President.
Yes, sir.
You see, a personal power has not been vested.
Yes, sir.
That is why the sanction address says that the union government, the central government has given sanction.
Yes, sir. In some cases, my lord, Article 161 said to the satisfaction of the president. In 163, it is not necessary.
It's
Write
not
down.
necessary.
161 necessary, my lord. It's to the
No, that's for different purpose.
Different purpose. I read here, my lord. It is true that recommendation authority is not attended with the sanction order. That is, I have not put signature on first and second page. If he is the assuming that he has the power, first and second page, why he has not signed? Suppose a letter has been given, we given the first, second page we sign. Only he last page signed. That is important because I'm repeatedly the Article 21 violated if a sanction order was not given. Second page. However, I have indicated first page of my own handwriting. It is not the fact.
Mr. Chaudhary, this will be a very difficult argument to accept. You see, now the for the purpose of a letter, at least to my limited knowledge, I have not come across any authority which lays down that a letter or a sanction letter or a sanction order must contain signature in every page.
I have looked at the
I'll just elaborate. You see, number one, if it comes to a registration of a registrable document, then it says that every document has, every page has to be signed, authenticated by the sub-registrar with its seal, and then it is registered. There is a requirement of the registration manual. In the act, it will not be there, but in the registration manual, it is there. You have to, every page has to be signed.
I have to look at this one.
No, this I am aware because quite a what you call quite some time was spent there. So so you see, so far as the letters are concerned or orders are concerned, now what happens? You see, it is only for the sake of convenience that we sign each and every page of the order so that it can't be changed at a point of time. But supposing this order which I'll be passing today, it's a 2-page order, I sign on the 1 page. Will that order be invalidated just because the page number 1 has no signature?
I know normally when you also go to the file, you'll also give the initial.
No, it is just a security. It's just a security, just a notion of security that when I have put the signature, it will not be replaced. But supposing I don't sign this today, the order which I am proposing to pass is a 2-page order. Supposing I don't sign page number 1, will that invalidate the order of the court?
I shall look into the judgment, my lord, because my personal opinion will not give. One thing is that, my lord, here is a very judgment when there is this stringent punishment has been given. Your lord, the honorable court has duty to look, my lord, strictly, not otherwise. If it is convicted, my lord, for 10 years, that judgment is available also. Because here stringent punishment has been given, my lord. Court has to strict. Capital punishment has been given.
We'll check it up today.
Yes, sir.
We'll call for a record from the registry and we'll check it out.
Yes, sir.
You see, just a loud thinking, nothing more. We will call for a record where a charge sheet has been submitted, and we'll see if the police officer has signed in all the pages. Means you see a charge sheet in the column. There's the signature of the officer at one particular column. There's only one column given for signature. So if a signature is contained in one page, and there's no legal requirement under the Assam Police Manual that all the pages of all the pages will be signed. That's one thing. Second, you see in the under you have CRPC, you see 173.
173.
You see, 173 requires what are to be given. So if there is a sanction order, it is added because of the provisions of section 45. It's a sanction which has to be given. Otherwise, you will find the satisfaction of why sanction was accorded is not a document to be submitted under 173. Satisfaction recorded by the competent authority. Like, for example, what happens in some heinous crimes, there is a requirement under the police manual to show it to the investigation. Progress of investigation is to be monitored by the circle inspector. But the note of the circle inspector is not required to be provided to the accused person when the case records or the case documents are supplied.
So sometimes, because my lord, sanction order is a public document. Sometimes, SP Gupta, I think, 1966. If it is attempt to wage war against the government of India, sometimes defense document were not given. I forgot that citation. Some document.
Sanction order is a public document.
Public document. Because sanction has been given, it was.
No.
When it was produced before the court, it was public document.
It's still a record of the court. It's not a public document.
The sanction passed by the competent authority.
Sanction is not a public document. I can't go and apply.
Yes, sir.
If X has been, there is a sanction against X, I'm not entitled to go and apply.
Yes, sir.
But a public record is otherwise available to be supplied to all.
But after filing of the search sheet, the accused is entitled for all the documents.
No. Accused is entitled to.
Yes, sir.
But you see, that doesn't make it a public document.
Yes, sir. Yes, sir. I understood your point. It is.
For example, otherwise they would the courts would not have power to frame rules and to say that in a POXO case the names are to be masked. In a POXO case, the no record would be made available to the third party without the order of the court. Those things are merely to show that even a FIR at a given point of time may not be a public document.
Yes.
Because now, there's a debate going on as to the public trial through a media trial.
Yes, sir.
So there is a debate going on. So here's again a question that why you see the court is normally to be open to public. So why something which is being deliberated in the court cannot be discussed in public? So why this debate if everything is a public document? Record of proceedings may not be a public document. Just what I feel. But I can't say for sure. It's just a.
In respect of sanction order.
So 173 will show you these are the documents which have been mandatorily supplied. It doesn't contain the satisfaction recorded or the documents received. Those things are to be produced. And if you correlate to the Assam Police Manual, then you'll find that even here in this CRPC, I'll show you something.
One thing is important. Sanction is an administrative order.
Yes, it's an administrative order. Yes, you're right. Absolutely right.
Yes, sir. That is I am submitting.
I'll show you something. Just a moment.
My lord, along with my lord, charge sheet.
Just a moment, just give me 2 minutes.
Yes.
This is forgotten. 172
Yes, my lord.
CRPC.
Yes, that. What is legal evidence? My lord? Diary of the proceeding of the investigation.
Yes, subsection 2.
Any criminal court may send the police diary of a case under the inquiry or the trial such may use such diary not as evidence in the case, but the aid of such inquiry and trial.
So you see, in our state, what is happening is that when what you call charge sheet is submitted, the case diaries are sent to the court. But that's not the requirement of law. The case diary is not required to be sent. There is a corresponding provision in the Assam Police Manual, where also there is no requirement to send the what you call the case diary to the court. But the court does have power to call it. It will not be used as evidence, only for the purpose of the court. It can go into. So you see, what you call those other communications. It will be in the case diary that the records have been sent to X for sanction. So that becomes a part of the case diary. It doesn't. What I'm trying to discuss is that there is no requirement under 173 to produce that before the court. Your argument we are accepting, but this is what we are discussing.
One thing is that, my lord, I am thinking about this. Now I am what their judgment, Sosikala and Authorized. After that, the accused is entitled to get the document relied by the prosecutor, not relied by the prosecution also. And that is why, my lord, if it
I
is
tell you, you see the judgment of what is said there is that all the documents which form part of the report of the police officer on completion of investigation, that will be sent to the court. And in the prosecution, you see, if you have seen the present CCTNS 5 module of charge sheet, you have seen that. In the CCTNS form of charge sheet, which the CBI is otherwise following, you will find that there are two columns. Column of the numbers I've forgotten. It says two things. Number one, a document are numbered and entered there. Supposing there are 10 documents. In the CCTNS form, they will write document number 1 to be proved by X, document number 2 to be proved by A, B, C, D. So there's no names are given. Then in the name of witnesses in the CCTNS form, you will find that witness X will come. X will prove what? It will be entered. He'll prove exhibit 1, document 1, and then a witness A, he is coming. What he'll prove? He'll be written against it, document number 2, so that there's a cross check of what is to be, what proof is to be adduced in the court. That's number 1. There may be some documents which form part of the police report under 173, but not relied upon by the prosecution for the case. So in that case, the Supreme Court has said that all the documents which form part of the police report must be given, whether you rely it or not. But it does not say a document which is not a part of 173 also has to be provided.
You also want to say sanction order is now part of document of 173.
Sanction order is there, but the records relating to sanction,
Record relating to
it's not a part of 173.
Yes, sir. You also understand.
So Sashikala is, I'm very sure about it. I'll show it to you. Just refer that part of Sashikala. Yes, the court was discussing the provisions of 173.5. 173.5 is when such report is case 170, the police shall also forward to the magistrate along with the report all documents or extract. So here in Sasikala case, it's a judgment which is reported in 2013 at 12/9 SCC 771. Here it says that here what had happened was that the unexhibited documents, certified copy application was made by the respondent, no appellant, and it was not given as it was not relied upon by the prosecution for the case. It is in that context of 173.5 that that it was held by the Supreme Court that it required all documents to be handed over, whether relied or not. That is this judgment.
I have to look all these points again.
No, this is something I have looked. That's why I am so confidently saying.
Yes, sir.
So we'll continue some other day.
Yes, sir.
Can you put it next week, someday, Tuesday or Thursday? It will go after vacation. My brother may not be
Yes, yes, sir.
available in the principal seat.
My lord will come when your lordship will come. We don't know.
Tomorrow is uncertain. We don't know about tomorrow.
23rd November, my lord.
23rd. Okay.
November 24, my lord. Tuesday.
Okay. November 23rd is Thursday, or 21st is Tuesday.
November 24th is the Tuesday.
No, you are next year calendar, I think.
Can it be 27,
27th is a holiday.
27.
No, lordship, perhaps lordship.
No, that I think that will be too long.
Then
We'll tend to forget. If it can be accommodated within third week,
13 minus
13th again is a holiday. In a lighter note, we can say you have heard about the English. There's also the equivalent Hindi, and in English it says valse of years.
No, it minus 14 November minus
14th.
yes, madam.
Okay.
Class
No. Yeah, only it's Children's Day. Since it is my day, no, we'll take it up. It's my day. No issue with that.
13 so Diwali minus
13th is a holiday. 14th is no issue.
16 minus
16th, okay. So Mr. Chaudhary is avoiding my days.
no, my say it's Diwali.
Okay. Mr. Anandi Chaudhary, learned counsel for the appellant, along with other learned counsel for the appellant are present. The submissions of Mr. R.K.D. Chaudhary done at you are appearing at DSGI, done at DSGI remains inconclusive. First list again on 16 11/20 in view of the ensuing Durga Puja holidays. Come on, this is the matter on 16 11/2023 as a part of matter. Respective benches will sit significantly after this. I will add here that this, since there's always direction to go there, we'll say that you will have the liberty to make a prayer to keep in evidence the proceeding till the decision of the suit.
Already your lordship has set aside your
No, you see,
revenue board order is final order. Revenue board order, your lordship will kindly see page 83 of the writ petition. That is the final order. That order has been set aside.
page
83. In the middle portion, 83 of the writ petition, after about 10 lines, it has also taken into consideration that the other litigations are pending before other forums. But despite this, the revenue board was passed. It's a final order.
Mr. B. Das, senior counsel, assisted by Ms. Adhika, counsel for the review petitioner, and Ms. A. Burman, learned counsel for the respondents.
The lordship may clarify, my lord, in view of the not necessary to go to the revenue board.
And this review petition,
Clarificatory.
by this application for review of the modification, clarification of judgment and order dated 6/6/2023 passed by this court in WPC 4172 of 2013. The petitioners case in brief is that as this court had set aside the order dated 17/5/2013 passed by the Assam Board of Revenue in Revenue Appeal number 135 public RA within bracket K bracket is public 2012. And having permitted the parties to proceed with the trial of PS 101 of 2012 with an observation that the said order dated 6/6/2023 under review would not prejudice both sides. When the proceedings of PS 101 of 2012 were decided on its own merit. Further adjudication is the parallel adjudication of the revenue appeal for the Assam Board of Revenue. Was not required as the orders passed in the suit will ultimately prevail over the decision of the Board of Assam Board of Revenue. Next part. The learned counsel for the respondent. Number 2. Does not object to set here. Next one. As this court had invoked the principles of res sub judice, taking into account the tendency of the proceedings of PS number 101 of 2012 to set aside the order dated 17/5/2015 passed by the Assam Board of Revenue in Revenue Appeal number 135 of the RA within bracket K bracket closed of 2012. Purpose of the considered opinion that the issue raised the dispute between the parties can be settled. It can be adjudicated in title suit number 101 of 2012, and therefore parallel proceedings before the Assam Board of Revenue in Revenue Appeal number 135 of the RAK 2012 would be necessary. So therefore, the order dated 6/6/2023 is modified by providing that it will not be necessary for the petitioner or respondent to subject themselves to fresh proceedings in revenue appeal number so and so before the Assam Board of Revenue. Guwahati. This order shall be read together with the order dated 6/6/2022 as per this court in WBC 4170 of 2013. Right. Will not be required to be subjected to the parallel proceedings. That's what I have said.
Daily list item 2.
Yes.
The two is the product of the document 25/7/2012 in manuscript number 45/2009. Particularly the issue 3, 5, and 6 were decided against the plaintiff. Two was recovery of money. Okay. What done by the plaintiff? By the plaintiff.
Actually, in this agreement, well, I have some difficulty to do. I prefer 1 day accommodation. For logic,
That is a prayer I will be refusing. We will give you the file if you require.
that code is required.
We will send you the records.
But, or kindly, if logic hears him, the appellant to the kindly logic may accommodate me for tomorrow. I have to just go through the
Okay, go through and continue with that.
The point will also will find. Page 7. Page 7 is the plan. And here you also will find the floor portion at page 15. Page 15 is the prayer portion. Here I sought for decree for recovery of rupees 85,19,300 against the defendant. That apart, recovery of the pendant like interest 12% upon 85,19,300 and then future interest 12% from the date of decree till recovery, then all cost. Then the also will find the issues were changed. At page 36. Page 36 is the issue.
Yes.
Issue number 1, the suit is maintainable. Issue number 2, whether the plaintiff is entitled to claim the pending bills of rupees 22 lakh with interest thereon, amounting to rupees 9,95,000 at the rate of 12% from the date from the defendant since the bill date till filing of the suit, and the plaintiff is entitled to claim the cost of bitumen amounting to rupees 8,08,000 with interest thereon of rupees 1,41,400. Then whether the defendant are bound to return the security deposit of rupees 3,60,000 with interest of rupees 23,400, and whether the plaintiff is entitled to claim the escalation compensation of rupees 39,91,500, whether the plaintiff is entitled to future interest or any other relief against the defendant. Here, the issue number 3, 5, and 6 were decided against the plaintiff. That is, the cost of bitumen, it was not given, and then security amount, sorry, the interest claim of escalation was not given, and then future interest, it was given, but at the rate of 9%. I was claiming 12%. As per the contract, the defendant are bound to pay 12% interest, but the court has given only 9%. Now, let's see the judgment will also be fine. Judgment.
You see, I got, so far as bitumen is concerned,
Yes.
this, is there anything to show that it was part of the procurement was part of your, was your, it was to be procured by you?
Between was to be supplied by me, and it was given to them for custody because the work could not be proceeded due to rainy season. And the executive engineer, he has a store in that place. So it was requested the executive engineer, he permitted me to keep the bitumen in his store. There is a written instruction is there. Accordingly, I kept there. And the document also I have exhibited. Thereafter, they say that we do not find any record with us. Because, but the record which they signed it, which we have exhibited here. Yes, so far the bitumen issue number 3 is there, and how the climate trial court has replied it. We see that at page 43. In the court examination also they have admitted. But the only thing is that they say that we do not have any record on that. Page 43.
Just wait for some time. Mr. Nath, please give me the file C1. Which is that exhibit? Hmm?
Exhibit 8, 8.1, 9 and 9.2.
8.
8. What is this? Invoice. If you purchase the document, 8.81 are the invoice. And 9 is that document which the approved engineer has signed it. Nine is the document for receipt of 42 numbers of document. Terms of document. And 9.1 is that 105 numbers of terms of document received by the SO store.
Your claim against this bitumen will fail.
Yes.
That claim would fail.
Yes, Stanford said that it failed to prove.
Correct. That's what I am saying. That claim would fail.
That's correct.
Answer is very simple. You see, there's a document or receipt. Who has received it? You are not saying. You are saying that the sectional officer has received it. What is the name? You don't know. That signature is not proved. You see, if you are proving a signature, what is the requirement of law? Somebody will have to say that this man has put the signature in my presence. I know his signature, and the person who has signed his name is not given in evidence.
And let us see the cross examination.
No. You see, first is primary proof. Cross-examining will come later.
That should have proved it.
No, he has not proved it. If you say this is proved, that is
For that PW evidence.
look at PW evidence. You see the strange way of giving evidence. In the paragraph, he doesn't say anything. It's only a statement of facts in the evidence. And in the last paragraph, he says exhibit 9 is the document, 9.1 is the document. Whose signature? Signature itself is not proved. 9 is a document, 9.1 is a document. So where is the proof of signature? It's not there. Merely marking of exhibit is not proof.
9 in the exhibit portion. 9 is the noting signature of booking number 5.
No, then you look at the record. Then you will understand. Look at this record.
receiving of the document from plaintiff.
That's I'm sending you the record. Mr. Nath, see that it will be relevant for you also. You see, this is a document 9, exhibit 9. Signature is not marked.
Exhibit marking is not, no?
Second page is exhibit 9/1.
Yes.
Signature is not marked. So there are in fact two documents and written wrongly in the evidence.
Signature and 9-1 itself to be the signature.
That's what I'm saying is wrong. That's why I said signature is not marked.
Which is the signature marking, because from the evidence it is
No, signature is not. You see the place where it is marked.
yes. Arrow marking is not there.
Not even arrow marking.
Yes.
It's not even near to that signature.
So 9-1 is near to the signature. 9-1.
Then what is? Where is the second document? There are two documents.
Yes.
One is 42 bitumen and the other is 105.
105.
So then what have you proved? If the signature is proved in the other page, what is the document you have proved?
The document, the marking is given some distance from that signature, but in 9-1 it
No,
is
no,
clearly evident.
Mr. Sharma. Two documents are different documents. In one first document you mark, these are two purchase vouchers in two different quantities. Now, in one document you mark exhibit 9. In the second document you mark 9-1. So which document you have proved? If you say that statement, that both the documents are unproved. You see, you have sold me, Mr. Sharma. Let us assume what you call example. It's only an example. You sell me this product, two pieces of this product by two cash memos. You mark one cash memo as exhibit 9 and the second cash memo you mark 9/1. What have you proved?
But in the evidence, this has been defined like that. I'm reading my note evidence portion. 9 and 9-1 are the noting and signature of defendant number 5
Can't be.
upon receiving of.
Then
the
you have not proved the document. If that is correct,
Yes.
that's what I'm asking you question. Then the bill itself is not proved. Your statement is writing and signature.
Bills are different marking. My lord.
No,
That
no,
is
no.
8 and 8-1.
Here you have proved only noting and signature.
Yes.
So 9/1 is what?
9-1 and 9 and 9-1 are the noting, are the signature.
So
And 8 and 8-1 are the vouchers. However, can we see the evidence, my lord? 8
you see,
and
without
8-1.
proving a document, you can't. Can you prove only a signature?
Here signature also.
AD is supposing an AD card has come. You want to prove the signature. Are you not required to prove the AD card? That exhibit 9 is the AD card. Exhibit 9/1 is the signature.
It is the photostat copy of 8 and 8-1. The 9 and 9-1 are the photostat copy of 8 and 8-1, where the signature markings are there. Can you provide
see-
the document as my evidence also, my lord?
No, evidence I could. You see, it's not attached to that statement. Statement says something else, and this your evidence marking is in the last, and there's no correlation.
The statement also, my lord, differentiated the marking. 8 and 8-1 are the invoice of purchasing the document from HSCL. Now the photostat copy of this 8 and 8-1 are the signatures of document number 5. 9 and 9-1.
that photo, that document which has been which has been shown, Mr. Nath, these are with you.
Yes.
Is it proved in original?
Yes, original is 8 and 8-1. And the photostat copy of 8 and 8-1 are the signature.
Look at the signature, it's not there. That signature is not the original signature.
Signature of the storekeeper.
No, in fact, exhibit 8 is also a copy. No? Exhibit 8 and 8
No, is it written approved in original?
compared to the original.
Compared with the original is there.
Yes.
Now look at this document again. Is that signature the original one in exhibit 9?
Compared with original is there, but signatures are not marked. That this is the signature of so and so. I know, which I know. That thing is not there. In the evidence also it is not there.
Entire document was compared and proved in original.
No, exhibit 8 doesn't bear that signature. Exhibit 8 is without signature, without that written portion. So 8 and 9 are different things. 8, 9, 8 cannot be the original copy of 9.
It is there.
Because 8 and 9 are different.
8 is the invoice from Hindustan Petroleum. And 9 is the photostat copy of that Hindustan Petroleum. Invoice number is same. You can compare both 8 and 9.
Where is the statement in affidavit with regard to this?
Yes.
Which paragraph?
In page 10. Statement is there.
Which paragraph?
And page 24. There are 24. There are 15 is there. There are 15 of
Mr.
evidence.
Sharma,
There are 15 of evidence.
paragraph 15. Paragraph 15 is that as per instructions of December number 3, I had deposited 147 grams of bitumen on so and so defendant number 5. I had completed so and so. So the manner in which the deposit was made by this making photocopy of the bill, that is not mentioned here. Now, para 24, I say that stock of so and so were kept with defendant number 5 under the instruction of defendant number 6, was holding the office of visiting engineer at the relevant time so and so, so and so. It was not written back to me. So here again, you don't say that the original bill were photocopied and then the signature of so and so was put. Evidence must reflect something that who is defendant number 5, who has signed it. No, but you see, the signatures are not there. Somebody must identify. As an appellate court, I must know who is the person who has received it.
You have made the defendant also in this case.
No, it's not by name. You see, you see, it's not an ordinary course of business for the PWD to receive bitumen from you. Now you say that you have given it to one of the staff. Who is the staff you don't disclose? You're making a poster party. Storekeeper.
This person also I made.
Where is that? Defendant number 5 is storekeeper. In your evidence, in your paint, defendant number 5 is the storekeeper.
Defendant number 6 was this person. Utpal Kumar Koitu.
But in your evidence, you write the signature of defendant number 5. Okay, this is issue number 3. What are the next issue? Which are against you?
Regarding the interest, 6.
Where is the agreement for that 12% interest?
Exhibit 2 to the NIT.
Exhibit 2.
Clause 43.
Exhibit 2 is the NIT.
Clause 43(1).
43(1).
Yes. Page 13. Percent is the rate itself.
12% per annum. Where is your bill? Exhibit 9.
9%.
No, exhibit 9 is that exhibit 9 would be your bitumen. No, your
I'm telling about judgment. Judgment. 9% interest that both are granted.
no. Which is a bill in respect of which payment were made? Where is that bill?
Remember the MB book. They have prepared the MB book.
No, MB book is not a bill.
Bill of what management?
No, the bill. Bill is something you will have to make. Then only payment will be made.
There's the MB book as per the measurement. What amount of work completed, they prepare the MB book and then they make the payment. That is the procedure.
No. Without a bill, no payment will be made by PWD.
The bills are also, that is 19P.
It's a construction work.
Yes.
So it will be bill of quantities.
Yes.
Bill has to be there.
Bill it is not disputed.
It's not question of dispute. You'll get it from the delayed payment, 12% from the date of your bill.
Following on the bill certificate.
Okay, so at least 12% interest you'll get. What is the other issue?
Other issue that escalation.
Hmm?
Escalation.
Cost escalation.
Yes. There is an escalation clause in MIT, that is clause 17.
When did you apply for cost escalation?
Yes. There are 5 and 6 of my claim. I stated that I have to remain idle for this.
No, where is the sequence of claim? 8.
That is there in the print bill of sale. There are 6.
Paragraph 6 of what?
There are 6 of claims. Start from paragraph 4 also. The plaintiff, after receiving the work order, started executing the work by engaging men and material at the site of the work. During execution of the said work, the plaintiff was asked by the defendant number 3 from time to time to change some major items in the work, which were not included in the original tender. And in accordance therewith, the plaintiff was also executed the work of additional items as ordered by the defendant. Later on, the defendant number 3 was asked by the office of the defendant number 2 had letter and the memo number so to submit the original tender document for the purpose of inclusion of the values of the approved supplementary works and the values of the said supplementary works amounting to rupees so. Then there are 6. The plaintiff has come to know from the defendant number 2 that prepared the revised working estimate for the restoration work with the change of the major item and send the same for approval by letter and the memo number so in 2006 to the defendant number 2 with a copy thereof to the other officials. The plaintiff was informed at the working site by the defendant number 3 after 11 months that revised the restoration estimate which was duly approved by the defendant and believing on the same, the plaintiff started execution of the
Mr. Sharma, you'll have to do something. You'll have to make a chart for me. You see, it's absolutely difficult. In the plaint, you see, in the plaint, you don't give reference to the document.
Yes.
In the evidence also, you don't give reference to the documents. So therefore, every time we have to read one paragraph, go back to the document, look at what the document is and find out. You make a chart for us, document wise. But this is something which I'll take days and days to understand this. By the time I come to the second document, I forget the first document. You see, in evidence, if you give in the evidence, if you say one statement here, and the evidence you don't say anything, what does it prove? I find it very difficult to.
You'll also ask me the escalation chart.
No. You see, you make a statement in the plaint.
Yes.
There you don't refer to any document.
Yes.
So therefore, how would I look at the pleadings? How would I correlate the document, and then how would I appreciate your evidence?
And the document will also be the evidence. Evidence which is
No, I understand.
Yes.
But if in your plaint you don't refer to any document.
Yes. And the evidence portion will also be find
No,
the
just tell me, if I supposing I make a presentation, I tell you that this is a diary so and so, and then in paragraph 1 I have stated this, then you refer to a document which is not listed there. You come to the document at so and so. In this document, this is stated. So you see, a document must state something which you have pleaded. And if you give evidence without pleading, that goes, that would not be admissible. How much right you say?
That's it, based on the pleading, my lord.
Based on pleading, you see, you have to refer to some document and say that what has happened in that document.
Yes, the document also I am very sorry. Regarding the escalation, we have also been find the document.
You see, if there is a cost escalation, number one, you will have to, before that, you will have to write to the PW authorities that there's a change in bill of quantities. Then you'll either accept it or not accept it. When they are giving you a change of bill of quantities, you are accepting it or you are accepting it with protest. If you accept it without protest, then you are not entitled to claim cost escalation.
No, that letter was given to them.
But how do I find it? Please assist me to find it out.
I'm sorry.
You give a chart-wise presentation if you are referring to anything. But this is, I think it will not be very easy to
You know, the-
follow you.
the second
Show me a document where you have accepted the alteration in the bill of quantities. Where is the acceptance? And have you registered a protest?
Yes. No, sir, absolutely. I'm sorry for that.
You see, it's your pleaded case that there was a breach in the embankment and therefore revised estimate was prepared after 11 months. And therefore you are saying for 11 months you are idle.
Yes.
Correct?
Yes.
Now, for that you can't be idle.
Because
If you are given a particular work to work, say for example, 20 meters of road you have to make.
you know, there was change in
No, please, please have some patience. This room has a breadth of 20 meters. For 20 meters, you have to construct a road. If you are stopped, if you are prevented from completing this part, then I can understand that it's a cost escalation. But you are given an additional work by change of bill of quantities. Why will you keep your man here?
No, my lord, without that additional work, this main work cannot be done. And that was not included in the original contract.
No, then you have exceeded your time of completion of contract.
Yes, we have extended.
It's not your case, not your pleaded case that during the tenure of your contract,
Yes,
there was a breach.
yes.
This breach occurred after your tenure is over. What is the time of completion in the agreement?
That time was extended by 10 months.
Where are those documents? You please show sequentially. Otherwise, I will not understand anything.
I will take an answer, my lord. I will give the sequence, my lord, the dates and the documents.
Yeah, otherwise, you are hearing a perspective. You see, without a sequence in your evidence, the sequence is not there. In your plaint, your sequence is not there.
I will give it, my lord. I will take an answer.
You exchange copies. You give it to Mr. Nath also.
In fact, GW1 in his evidence has exhibited one document as exhibit C, and that is what he has said that you have already completed that work long back. So there is no.
After that,
waiting.
there was a breach.
There was breach. So 11 months. So there is no waiting for it.
There's no waiting period for them. That's what I. That's what I gather.
While citing issue number 5, that has been recorded by the land court.
No, maybe because you see, I have not seen the documents. I have not, because that is the natural consequences when you are doing a work. If the time of completion is there, there's no question that you are waiting.
In the midst of the work, he was not stopped.
I will give it, my
In
lord.
the midst of the work, he was not stopped.
It is not stopped.
He has completed because he has
Perhaps.
said that about completion of the work long back. Then that subsequent has come.
So if Mr. Nath is right, then you are not entitled to even that.
No, my lord, that is
So only
not right.
interest of 12%. That is the only thing you will be entitled to.
Regarding that finalization of the pending bills, that letter was, but my language that is referring, that is not regarding that. My pending bills were not finalized. So for that letter was issued. Now, maybe taken on some other day, I will give the details.
What is the date of change in the bill of quantities? What is the date?
2006. I think in 2006. Dependent prepared the revised working estimate for the restoration work with the change of the measure items and send the same for approval. And letter enter number also dated 10/7/2006 to the defendant with a copy thereof to the other officers. I was informed at the site by the defendant number 3 after about 11 months that the revised restoration estimate were duly prepared by the defendant.
One aspect.
That's one. Which is the exhibit letter dated 12/9/2007. Twelve nine seven is not the is not a
21/9/7. 12 of 21.
no. Mr. Sharma, second, I don't think you'll be entitled to get because of the fact that there was an extension of time till 30/9/2007. So therefore, your contract was otherwise to be completed within 80 months was 2010/2006 was extended to 30/9/2007. So if the change of bill of quantities is in between that, you're not made out a case for idle work. payment for idle charges.
I will tell you, to change the specification. and
No,
all
no,
the
but
things.
whatever be,
Yes.
you see, your original work was extended.
Yes.
So question of there being an idle charges is not there, no matter how much you argue. It's only the time consumed in arguing. But but you can't effectively say when there's an extension of work granted till the particular time, that is accepted without any objection.
Extension was not given due to idle working manner. Due to the
No, no,
violation
but
of-
you accepted that extension of time.
Yes.
Having accepted it, how can you now say that you are idle?
No, not due to that reason that we are sitting idle. For that
No, no,
reason,
you are claiming idle charges. You are claiming idle charges. That's what my question is pointed towards idle charges. When your work has been extended,
Yes.
you see, for example, your instructing counsel, we send him for what you call the court commission to inspect some place and come back. And now we extend the time. We first say that you do it within 24 hours. And then we say you do it for within 3 days. So if within 3 days, if he's submitting a report for 2 days, he can't claim that he was idle, and therefore he should be given idle charges. It's a wrong example. Example is inappropriate, but it's only to explain. You see, when the tenure is extended, you're not idle.
my lord, idle charges I am claiming. Let my lawsuit be right. I am claiming that my workmen were there, my machineries were there, and it remained idle. It could not work, and I had to pay for that.
No,
For that, I
no. Let me put you another way. You see, this 20 meters road I was saying, the 20 meters road is to be constructed. You are given 30 days time to do it. You are an able contractor, you do it in 1 hour, 20 meters. You say 20 meters, no problem. I do it in one hour. You complete it. So during that 30 days period which you are given, can you claim idle charges?
There is not on that extension, my lord, I am claiming idle charges. Because my main and everything were there, I had to pay.
No, I understand. That's why I'm giving an example. I have given 2 examples. One was inappropriate, so I have changed my example. Now I have given this 20 feet road. You are an able contractor, you do it in 1 day. Time was 30 days. For 29 days, can you claim idle charges? Answer would be no. Because your period is 30 days
But
to do that work.
when I was allotted some work, I had to complete the work. Then they say that no, you have to do that work also. And without doing that work, I cannot start this work. So for that, I have to keep all the machine, man and machinery there remain to be idle. And I have to pay for that. It is not a matter of extension. Extension was granted due to the rainy season. And they have also accepted it. It is not due to that I was.
No, can't be accepted. That's why I'm giving you dates. That's why I'm giving you dates. You got the contract awarded on 24/2005. That is April. You have to do it by 2010/2006. From 2010/2006, you get an extension till 39/2007. So when extension was granted on 20 with effect on 2010/2006, that was not a rainy season. No, I'm just questioning you because you present on the documents, the paragraph, the claim and the documents. It will be very difficult for me to read the statement and then go to the document, then again come to read the statement.
I will make it short.
The plaint statement in the plaint, evidence and the document.
Yes, I will
This
make-
chart 3 things. You by default you get a opportunity. It goes after vacation then. Okay, on the joint prayer made by the counsel for both sides. Matter stands exam today. Based on date delivered. Next, on that day, the learned counsel for the appellant shall provide a chart showing statement showing the claim-wise statement made in the plaint, evidence, and the referable document, document to exhibit, with a copy to the learned counsel for the additional senior government advocate for the respondents.
For motion.
I'm on a phase one call for the petitioner. For instance, just the matter stands adjourned today, based after a week.
Item 4.
This petition has been filed, my lord, for transferring of the case, my lord, from Borpeta Principal Judge Family Court to Guwahati.
What is the difficulty in appearing here?
My lord, there, my lord, since she has 9 months baby, my lord, and only her old aged mother is there, my lord. She cannot already premature baby is there. That is why, my lord, all the time she has to look after the baby and she has to go to the doctor, and even she has been given the threat by the husband. And since the husband is a PWD first class contractor and frequently is visiting in January, so but, now
Those things has no merit. Threatening is doesn't have any merit. You don't lodge an FIR.
that since she has come back to her matrimonial house,
No, that is okay. You see, when there is a family dispute, matrimonial dispute, you're not in good terms. That when you receive a threat, you will not lodge an FIR. So that doesn't have merit, but yes, your child is premature. We'll issue notice on that.
since here,
It's okay, I'm issuing notice. Heard Mr. B. Chetty, counsel for the petitioner. The petitioner, by filing this application under section 24 CPC, the petitioner, who is the estranged wife of the respondent, is seeking transfer of the proceedings of ES within bracket M, case number 157 of 2023, from the court of Principal Judge, Family Court Barpeta, the Court of Principal Judge, Family Court Kamrup and Guwahati, for the grounds for the reasons assigned in this petition. If you notice, returnable in 4 weeks. Give a fixed date for appearance. The petitioner shall take steps within 2 days. Posted track report. Next paragraph. Pending as an interim measure until the next returnable date for the proceedings of so and so pending before the court of so and so Barpeta, it shall remain state. Next paragraph. The petitioner shall produce a certified copy of the order before the Court of Learned Principal Judge, Family Court Barpeta, to bring the order to the notice of this learned court. List on so and so.
15th November.
15 November.
published.
But
Item
take
5.
steps within 2 days. If you don't take steps, we'll vacate the orders. Interim orders passed and the non-taking of steps will vacate on the next day.
Item 5.
Yes, why you can't go? Why you can't go to the court?
My lord, I am transferred to Jorhat, my lord. Staying here in Jorhat, I have children, my lord, small children.
You are in service. What is your post in which you are working?
Audit officer, my lord.
Huh?
Audit officer.
Then you are not in disability.
Well, I cannot come and stay here, my lord. I am leaving my children.
No, you don't have to stay in a family proceeding. I have not seen any party staying here to do the case.
Now, from Jorhat to Guwahati, my lord. It's difficult for me, my lord.
But you see, you are not a person who can't travel.
My husband is a free person, my lord. He's a businessman, he can go there.
Same order. Matrimonial case from. You want transfer from which court to which court?
From the principal judge Guwahati, my lord, to that district judge.
Principal Judge, Family Court number 1, Kamrup Guwahati, 2, Court of
Judge.
the District Judge Jorhat.
No.
Same notice stay. Steps within 2 days. And the certificate copy you will have to produce before the trial court to bring the order to the notice of the said court. Oh, it's just Miss IC data for the petitioner. Date. So same day.
15/11. Item 6.
The intervening petition was rejected. Mr. R.J. Das, counsel for the petitioner, by filing this application Article 227 of the Constitution of India. This is 115 or 115? Uh, 115 CPC is 115 that is section 115 CPC. Come on. The petitioner has assailed the order dated 13/6/2023 passed by the learned civil judge junior division Kamrup Metro Guwahati, by which prayer for impleading
Two defendants. Page one.
two defendants.
Page 1, page 2.
The 2 persons as defendants was rejected. No, so 2 petitions by petition number 524 of 2023 dated 21/2/23 was rejected. You should notice returnable on so and so. Steps postal track report till the next return will date for the proceedings in TS number 103 of 2020 pending before the Court of Learned Civil Judge Junior Division number 1 Kamrup Metro Guwahati shall remain suspended. Next, the petitioner shall produce a certified copy of the order before the learned trial court to bring the order to the notice of the said learned court.
Deeply obliged.
Item 7.
Yes.
Your Lordship, the petitioners are the legal heirs of the deceased defendant in a suit for specific performance which is filed before the learned civil judge Dara. In this case, Your Lordship, the deceased defendant was sued in his capacity as a power of attorney holder. The defendant,
Who are you?
I'm the legal heir of the deceased defendant.
Yes, substitution was allowed.
Yes, Your Lordship.
You agree by that?
Substitution was allowed without issuing notice to us. And
Where is the
on-
requirement of issuance of notice? Under which law?
Yes, Your Lordship, there are judgments by the Honorable Supreme Court.
Which paragraph?
Your Lordship, I have a convenience set which I've prepared, where I've marked the paragraphs.
Pardon me?
I have a convenience set which I've prepared where I've marked the paragraph. Your Lordship, the law says that before any party is included as a defendant, an opportunity to be heard has to be given to that party to first determine whether or not the right to sue survives. In this case, Your Lordship, because the defendant
No,
was
no, unless you tell me the paragraph, it will be very difficult for me to follow you.
Yeah.
Which paragraph?
Your Lordship,
You're giving this citation.
the first paragraph, Your Lordship, in the citation, the first limb of this rule.
First paragraph. This is an appeal by certificate of High Court of Andhra Pradesh on valuation of the subject matter and is directed against his judgment.
Your Lordship, I request that you refer to my convenience brief where I've marked the paragraph.
No, you see, this is something else, but I must find that paragraph here also.
Your Lordship, may give me.
Yes,
one
yes.
second, I'll just-
If I am to author my judgment, I have to know which paragraph you are referring to.
Apologies, Your Lordship.
We'll take it up after some time. You do the marking. We'll take up next matter.
Yes, sir.
Item 8.
In this case, the petitioners are the plaintiffs. They filed a suit and an
Additional notice. But Mrs. R. Chaudhary, counsel for the petitioner. Next paragraph. This the revision under section 115 CPC is directed against the order dated 19/9/2023 passed by the learned civil judge within bracket senior division Morigaon in Miss Appeal number 9 of 2022 or thereby allowing the appeal under order 43 rule 1 R CPC by setting aside the order dated 23/8/2022 passed by the London Municipal number 2. Which place? Morigaon. In Vijay case number 73 of 2022. In TS 64 of 2022. Thereby granting injunction. First up by the impugned order, the order of injunction granted by the learned trial court was set aside on the ground that if the petitioner is dispossessed, they can amend the plaint and seek appropriate remedy. for which the petitioner would not suffer any, petitioners would not suffer any irreparable loss and injury. Next. Issue notice, returnable so steps. Within 2 days. Next paragraph. Till the next returnable date, comma as an interim measure, the operation of the impugned order dated 23/8/2022 passed by the learned. No. What is the impugned order?
72 Lordship, 19/9/2023.
19/9/2023 passed by the learned Civil Judge Senior Division, Morigaon, in Miss Appeal number 9 of 2022 shall remain suspended.
I'm
Oh, you are
waiting for
there.
Respondents 6 and 7.
Oh, acha, I didn't see you. Okay. Mr. K.K. Bhattacharya, learned government advocate appearing for a small number
6 and 7. The
6 and
status-
7. Put it here first. Hurt so and so and so and so. Did you right? It appears that the respondent numbers 6 and 7 are merely a formal party. Let's stop. Then next. Huh?
Injunction order was against circle officer also, Lordship.
I've suspended this order.
Lordship. So they are necessary party officer.
You know how to deal with it.
Lordship. Now,
What did not in my book?
Item 770 paragraph 2 confirm with ATM appealing. Item 7.
The Lordship may have paragraph 28 of the judgment.
Have you read this? Are you satisfied that what you are arguing is the correct position
Yes, sir.
in para 28?
Yes, sir.
Read this para 28 again.
The first limb of this rule of audio alternum partem is that a person must be given an opportunity of being heard before a decision one way or the other affecting him is recorded. As
Now,
a
how does this order of impleading affect you?
Your Lordship, our case here is that the right to sue does not survive upon us for the reason that the defendant was sued in his capacity as a power of attorney holder. And the sued property does not, we do not have any right, title, or interest in the sued property.
You don't have right and interest. Your
Yes.
power attorney holder.
Yes, sir.
Where is that?
Your Lordship, I filed a copy of the claim. Your Lordship,
Which page?
page number 120 of the running case number. Additional affidavit. that we filed.
120.
120. Your Lordship, the operative part starts from page number 121. Paragraph 4 and 5.
Please read that paragraph where you say you're an attorney.
Yes.
Read that.
Your Lordship, that late Shiva Prasad Sharma died leaving numbers of legal heirs who sought to sell the land bearing various patta and dag numbers to various purchasers. That all the legal heirs of late Shiva Prasad Sharma authorized the defendant, one of the legal heirs of the late Shiva.
So you are a co-owner
Your Lordship,
and you are authorized. So your estate remains.
Your Lordship, the distinction here is that the claim gains.
No, no. Have you made any statement that you You don't claim any right and interest through your father or predecessor interest.
Your Lordship,
Where is that statement?
I'll come to that. The claim, the suit deals with two different immovable properties. Your Lordship. Schedule A and Schedule B. Now, while Schedule A property was one of the properties originally owned by Shiva Prasad Sharma, Schedule B property, on the other hand, is the exclusive self-required property of a third party who has not been included in the suit. It was never originally owned by Shiva Prasad Sharma, and we do not have any right.
Oh, that is your part of the case. We are not hearing. This is not an appropriate stage to hear that defense.
Yes, sir.
You see, you say that the defendant
Yes, sir.
was an attorney. So where is the document to show that he is an attorney?
Your Lordship, it's they have not filed. So what we are saying is that this suit has been instituted on the basis of their claim that this is
That plea you'll have to take there. You see, you claim that your notice should be issued to you. You show me a ground that notice has to be issued to you.
Yes.
You are one of the legal heads of Shiva Prasad Sharma, this Shiva Sharma.
No, Your Lordship, of the deceased attorney holder.
You are making me read paragraph 4 and 5.
Your Lordship, this was the original claim, and then the defendant has since died.
This is, you see, please try to follow what I am asking. You see, you are making me read paragraph 4 and 5. Paragraph 4 and 5 says that one of the Shiva Prasad Sharma died leaving number of heirs, and you, one being the legal heir, you are authorized by all.
Not me, I am the legal heir of the agent in this case, Your Lordship. The deceased defendant had been authorized, but upon the death of the agent, it automatically cannot be enforced against me. And this case, this entire.
That's what I am
case has
asking you. I am asking you for the second time that you have no interest in the property of late Shiva Sharma.
Yes.
Where is that statement?
Yes.
And that you are the attorney. You are not the.
Your Lordship, we have.
You are not the principal.
No, Your Lordship. Your Lordship may have paragraph 28 of my petition
28.
at page number 29. Yeah, paragraph 26 and then 28. Your Lordship, the title suit is for the enforcement of it's a suit for specific performance of an agreement to sell which was purportedly entered into on the strength of a power of attorney. In this case, Your Lordship, a contract entered into by on the strength of a registered power of attorney and obligations arising from acts done by
No,
this-
power attorney, we don't know at this stage. Don't refer to power attorney. This is not on record. It is not the plaintiff's case that he sued the attorney. His case is that he has sued a person who is legal heir of Shiva Prasad Sharma.
Your Lordship, it is the plaintiff's case, and this fact has also been acknowledged by the learned trial court. Your Lordship,
Oh,
we have
that's that. This is not a stage to hear that.
Your Lordship,
You must show from the documents which is there, or the materials which is there on record, that your predecessor was an attorney. If there is anything in the plaint, we will accept that, but that's not there in the plaint. It will be your defense in the suit, whether you are you had the right title and interest, who had the right title and interest, who was the owner of the property. In an application for implement, that is not the ground to be. There's not a point to be adjudicated.
Your Lordship, it is their case that they are relying on the
They have merely implemented you. It's not the case right now. They are merely stating.
However, Your Lordship, first there has to be a determination on whether or not the right to sue survives. It is
Right to sue survives. Because the limited within 30 days he has done that impleading. You say that you are not the legal heir. You're not the legal heir of the deceased.
the Lordship, we are the legal heirs of the deceased, but he was only impeded in his capacity as an agent.
That you take a defense in the suit.
Your Lordship, that is the issue here because he has.
In this, no. That issue will come when you appear in the suit. Order 1 Rule 10(2) is not an issue.
Your Lordship, we have filed those applications. The issue here is that the application under Order 22 was disposed of without issuing notice. And we went unrepresented when the court determined the question of whether or not the right to sue survives. It is a simple case, Your Lordship, that notice had to be issued to us in the first place to give us an
That contention
opportunity.
can't be accepted. When it's a case of substitution done within the period of limitation, you are not entitled to a notice. You receive notice as a defendant and then you appear and take a defense. Order 1 Rule and 2 doesn't decide any right title interest. You're not accepting that contention. Ms. M. Das,
Yes, sir.
Ms. M. Das, counsel for the petitioner, and Mr. K. Rahmat, counsel for the respondent, caveator. You file a caveat?
No, my lord.
Oh, you're not a caveator. You filed wakalatnama.
Yes,
When?
today itself.
Was entered for the respondent by filing wakalatnama today. Next para. By filing this application under Article 227 of the Constitution of India, the petitioners have assailed the order dated 11/8/2023, passed by the learned civil judge Senior Division Darang in Miss Case number 38 of 2023, rejecting the application filed by the petitioners under section 114 CPC read with order 47 Rule 1 CPC for review of the orders dated 6/6/2022 and 28/6/2022 passed by the said learned court in TS 16 of 2019. Next paragraph. The facts leading to this application is that one Om Prakash Sandilya, SANDILYA, is the sole defendant in TS 16 of 2019. So the sole defendant died on, what is the date of death?
20th of May 2020.
20
20th of May.
20 May 2022. Where is the substitution application? Which page?
Your Lordship, till date, we don't have a notice of the substitution
Oh, you
application.
don't have that. But in the order it will be mentioned.
Or Annexure A1, Your Lordship,
Page.
at Annexure A1 at page number 87.
87.
Order dated 6th of June.
On it appears from the order dated 6/6/2022 that a petition for substitution bearing petition number 1404 of 2022 was filed under order 22-4 CPC with a prayer for substituting the legal heir of the deceased defendant. The said petition was put up on 28/6/2022 for objection, if any, and on 28/6/2022, the learned trial court had allowed the prayer for substitution and issued notice on the newly implicated legal representatives. Next, agreed by the said order of allowing substitution, the petitioners who were substituted as defendants had filed a review petition Where is the review petition?
Your Lordship, the review petition was registered as miscase.
No, where is that? Which page?
That is not a list.
It's not there. Okay. Review petition. Officers. Wherein the petitioners have raised a plea that their substitution was allowed without issuance of prior notice and without hearing them. Full stop. The learned trial court observed that the right of sue had survived, and therefore the review petition was rejected. The cost of rupees 5,000. Next paragraph. The learned counsel for the petitioners has submitted that submitted by referring to a copy of the paint that the predecessor, namely Om Prakash Sandilya, was implemented in a representative capacity as an attorney and it is submitted that being an attorney, his legal his representatives could not be substituted to settle them with and subject them to defend the suit for specific performance of contract. First off, it is also submitted that the learned trial court had erroneously decided the point that the right of sue survives, and in that connection, it is submitted that the suit land is described in two schedules, being Schedule A and B, and that the Schedule B land is owned by different persons and is unconnected with the interest of the sole defendant. Sole defendant. Full stop. It is also submitted that before substitution, a notice was required to be issued mandatorily to the legal representative sought to be impleted. And by not issuing a prior notice, comma, the right of hearing of the petitioner was petitioners was curtailed. And in support of this submission, comma, the learned counsel for the petitioners has placed reliance on the case of N. Jairam Reddy, JYARAM Reddy REDDY, and others versus Revenue Divisional Officer and Land Acquisition Officer, comma, Konur KURNOOL. The relevant paragraph 28 on which reliance is placed is quoted below. The observations made by the Supreme Court of India in paragraph 28 quoted above, comma, is not a decision to the effect that before implementing the legal representatives within the period allowable for substitution, comma, the legal representatives are entitled to a prior notice. Full stop. Therefore, comma, the reliance on this said decision does not help to espouse the point which is urged by the learned counsel for the petitioners. Next paragraph. In the plaint, comment is seen that a statement has been made to the effect that the predecessor in interest of the petitioners, namely namely Om Prakash Sadilya, comma, since deceased, was one of the legal heirs of late Shiva, SHIVA, Prasad Sharma, SERMA, and was authorized by the other legal heirs to sell and contract with the purchaser. Full stop. Therefore, comma, the predecessor of the petitioner, being one of the legal heirs of the estate of late Shiva Prasad Sharma, comma, insofar as substitution of the present petitioners are concerned, comma, the court cannot find fault with the impugned order passed by the learned court below. Full stop. Nonetheless, the issue as to whether the substituted petitioners would be whether against the substituted petitioners, comma, the suit would be maintainable in respect of the other co-owners is a question which is left to be decided by the learned trial court and cannot be a subject as the same cannot be a subject matter of the adjudication which arises out of an application filed under order 1 rule 10(2) for substitution. Full stop. It is not in dispute that the petitioners would otherwise inherit the legacy, comma, if any, left behind by the sole defendant, Om Prakash Chandilia. So therefore, insofar as the impugned order is concerned, comma, the court is unable to find any jurisdictional error committed by the learned trial court to allow substitution. Full stop. Next para it is made clear that this order is confined only to the legality of the order passed by the learned trial court to allow substitution, as well as the rejection of the prayer for review. Full stop. Therefore, comma, nothing contained in this order would be construed to have determined respective rights of any of the parties to this to this application. First of therefore, comma, this petition is dismissed. Next paragraph. Both sides who are duly represented by the respective learned counsel shall appear before the trial court on the date fixed and await further instructions from the said learned court. But don't worry, you're done well. So argue before the court with registration of 2020, you have done well. Only that I am not with you. Yes. But keep it up. Keep your spirit.
Item 9.
I find this revision petition against an order whereby
Mr. Pathak, there is nothing, but I am only following your what you said. This young people should be encouraged for a better tomorrow. She has done her duty. That's why I put in a word for appreciation. Yeah, that's why. That's why. Yes, Mr. Dekar.
this is a revision petition against an order whereby my application under order 1 rule 10 has been rejected. Lordship.
Rightly so. Rightly it appears so.
In my view, this is I have some other view. Lordship. The lordship, the only two. Lordship. Since,
No, you see, your in the sale deed, there are several people who have purchased in common in a joint sale deed. Your right is limited to 2 katha 10 lacha. How you will be aggrieved?
That is my case, Lordship. Because Lordship, today I have a sale deed and there is common buyers, Lordship.
No, who is passing any order to determine to undermine your right?
No, Lordship, may kindly see, I'll just show the prayers, Lordship, and also the agreement, Lordship will be clear. Lordship, may kindly see page number 22 first.
Page 22.
Lordship, that is, which is the prayer portion, Lordship. A decree for specific performance of a contract be passed directing the defendant to execute the sale, registered sale deed in favor of the plaintiff on receiving and remaining the consideration amount from the defendants in respect of the land described in the schedule below.
So you're not a party here.
I am not a party here.
Correct.
Lordship, may kindly see the schedule. In page number 24. Now, Lordship, a plot of land measuring 2 bighas, Lordship, found it, Lordship, in page number 24. Land measuring 2 bighas covered by DAG number 102, Patta number 189 of Dhankheti Kothar under Botodua Moza in the district of Nagaon. Lordship, may kindly see the schedule in the north, same Jaharuddin, south Jalil Master, east Junab Ali, and west Abdul Jabbar. Now, Lordship, may kindly see the sale deed, which is the agreement for sale, in page number 27. As per the sale deed, Lordship, there are a lot of land, Lordship. Out of that, this is also one of them. The 2 bigger land, Lordship, it's on page number 27. The same, Lordship, the same DAG numbers. Now, Lordship, would kindly turn to page number 34.
You see, come to the impugn order first.
Lordship.
Here, you see the observation of the trial court.
But it starts from page number 50, Lordship.
Now, the finding that 2 kata 10 lecha is
Is included, Lordship.
no, is not included. Doesn't say that.
That's what from the schedule, Lordship. I'm showing the schedule. Lordship, may kindly see the schedule. If before going to the impugn order, Lordship, may kindly see page number 34 once.
Yes, you come to page 49.
Lordship.
49 says, admittedly, the petitioner is not a party to the contract. So this is a finding of the court.
Yes.
The learned counsel for the your submissions have been examined. It says that the petitioners that all that you're right. It says you have not entered into an agreement for sale for plot measuring 2 kata 10 lichas of land. So once the court accepts it, that contention that you are not a that is not your land which is which you have sold. So why in a suit for specific contract you will be a necessary party?
Lordship, this is a finding, Lordship. On case, Lordship, may kindly appreciate one thing, Lordship. From their document itself, this is purpose, Lordship. Why, Lordship? Is because Lordship, may kindly come to page number 34, Lordship.
30?
34.
Oh.
And this is the sale deal, Lordship.
Yes, I've seen that. That's why I'm aware that 2 kata 10 licha is yours.
Yes, Lordship. Now, Lordship, the court has come, rightly or wrongly, supposedly, Lordship, that I am giving a false statement that may not be there, that land may not be mine. Lordship, on the face of it, if I am today, if I go up to a court and say that this is my land, and my land has been subjected to an injunction.
Correct. Let us take a horrible examples which I am always giving. One of the worst examples, but still, you see, A and B enter into an agreement to sell Taj Mahal.
Lordship, exactly, Lordship.
Correct.
Lordship.
Now, Anybody who has interest in that sale of Taj Mahal, can he be allowed to be implemented as a what you call necessary party in this suit?
My lord, if there is if there is a sale deed in respect of the land where the Taj Mahal is situated, lordship, then yes, lordship.
No. You see, this is why I've given the example of Taj Mahal. You see, Taj Mahal is a national monument. So even if I enter into an agreement, this decree will be inexecutable. And if there's a decree for specific performance of contract, and assuming that your land is decreed, you are not a party, your title cannot be taken away. You see, the entries in the record of right, there your name can't be deleted, even if a sale deed is executed.
No, my lord, but in this case, lordship, in this case, there is an injunction which is running against my land, and knowing fully well.
Where is that
land-
injunction order?
Lordship, this is part of the pleading, lordship, but I have not annexed the injunction order, lordship. But admittedly, my lord, there is a status quo order running in against me, my lord, and that is how I have come to know that my land has also been included within the scope of this.
You show it from your petition if you have made a mention of that.
Lordship.
No, order 1 rule 2, then 2.
Then my page number 7, lordship, may kindly see 7, lordship. Page number 8, lordship.
Page number? No, in your implementing application, have you made a statement about injunction against
Yes,
operating
yes,
as
lordship,
you?
I have made, lordship. I have made, lordship. Page number 6, lordship, pair number 3. The petitioner stated when notices were issued to respond number 3 and 3 to 7, the said respondents entered into an
No,
appearance.
you're reading which page?
Page number 6.
No,
lordship.
not this statement. Your implementing application. In the implementing application, because the trial court, the implementing application was there. Have you made a statement that there is an injunction operating against you?
Lordship, in my implementing application, lordship, yes, lordship, what I have done, lordship, in the implementing application also, my lordship, in the injunction also, lordship, I have filed an application that is pending. In the injunction application, lordship, I have filed a separate petition, lordship.
But please tell me, what is the injunction?
Under order 39 rule 1 and 2.
No, what is the injunction status quo?
That,
Now, please tell me if you are not a party in the proceeding, is the injunction or what you call applicable on you?
Lordship, right, that has been given effect to lordship. Because lordship, that is the exact reason why I want to be a party in the suit.
No, but you must demonstrate something more. You see how the status quo has affected your right.
In my humble submission, lordship, the status quo order is directly affecting my land, lordship. Now I cannot enter into that land because of the status quo order. What has happened?
You can't enter into the land.
No, because what has happened, lordship, that's a fishery. Now the fishery has been given on lease to the other petitioners, lordship, other defendants, lordship. Now the defendants have decided to sell the land of their own, lordship, and along with that, schedule of my land has been annexed, lordship. Now because of that, lordship, the suit is filed. Even though the suit doesn't bear my name, lordship, my land is included there. Now, in a suit where my land is included, there's an injunction order which is running against me. Lordship, if I am not heard, lordship, it's a direct violation, lordship.
Mr. Dekha, these things I'm unable to accept. You see, the trial court, that's what I'm showing the order. The trial court says that your land is separate.
No, lordship, that is beyond the record, lordship. Lordship, I kindly see.
You are yourself saying that 2 kata 10 lachas is yours.
Yes,
If the
lordship.
trial court is excluding that, you are saying that now it is beyond the records.
No, lordship, I kindly see the order once, lordship. That has not been stated by the trial court, lordship. Lordship, I kindly
I
see-
showed you that. I can't every time find it out for you.
lordship,
I was reading that part. Page 49. Admittedly, the petitioner is not a party. That is the finding of the court.
No, but I am not a party to the agreement, but that will not make my right and title over the land go away, lordship. I have the plaintiff and me have not given any agreement, lordship. But in the schedule, my land has been
Please read
included,
this
lordship.
paragraph. It has excluded 2 kata 10 lachas of land.
No, my lord, may kindly see the agreement for sale, lordship. That is the agreement for sale, lordship.
You see, agreement for land. Let us think of any great person who has done an agreement. Your land is being sold. Can you be a party in a specific performance of a contract?
Minor may kindly rely on the judgment which has been already led by the trial court lordship. I would find there's two principles which governs this lordship. First principle, may I just
Please read this paragraph 49. Admittedly, the petitioner is not a party. This is a finding of the court.
No, my lord, I am not saying that, lordship. I have never stated that I have entered into an agreement, lordship. But when there is an injunction.
No,
which is
you are
running-
absolutely misconceived. Either you are misconceived or you are not. You are not following what my question is. You see, the trial court, you give a petition for impleading. Trial court says it's a finding of fact recorded. Admittedly, you are not a party to contract, and that you have right over 2 kata 10 lashes. That is accepted by the trial court.
Yes, lordship. And that is the reason.
And then
why-
also you say that you want to be a party in a suit for specific performance.
May I just read it, lordship, once, lordship? May I just read?
Definitely, you read it 100 times. Nobody is stopping you, but you can save my time.
But
You can
just-
take it
just-
some
just
other
one
day.
minute, I'll just read one, lordship. May I
Uh-huh.
please hear, lordship? Admittedly, the petitioner is not a party to the contract. The title suit has been filed by the plaintiffs against defendants for specific performance of the contract. The learned counsel appearing for the petitioner has submitted that the petitioners need to be added as a party as his presence is very necessary to adjudicate and settle the dispute. The petitioner has further stated that he has not signed the agreement for sale dated 17/5/2019 and has not entered into an agreement for sale his plot of land measuring 2 kathas 10 lashes covered by Doug number so and so. The petitioner has alleged that the opposite party number 1 and 5 have exhibited the agreement by including his plot of land in the schedule of the agreement. The opposite party has contended that the suit is completely different from the land described in deed number 764 of the 1993 of the petitioner. Therefore, the third
So you
party has-
see, it is the plaintiff who is saying that it is not the sale deed land.
My lord, may
Land is different.
And kindly say this is what I have stated before the court also. This is not the observation of the court also. This is what I have said. Lordship, may kindly see the observation also.
Then I'll have to go back and learn English. You see, first line is admittedly the petitioner is not a party.
My
That
lord,
is number one.
my lord.
In the last 5 lines, it is stated that the opposite party is stated that the land of the suit is different from sale deed number 784.
My lord, lordship, may kindly see.
So opposite, who is the opposite party here? Who is the plaintiff?
Lordship, may kindly see the deed, lordship. The deed, lordship.
Why should I go into the deed when the court is giving a finding of fact?
Lordship, in my humble submission, if I may, lordship. Lordship, this paragraph is not a finding, lordship. Lordship will find the finding in page number 51. It starts from that, lordship.
51.
Lordship.
Okay.
This is how it starts, lordship. Since the respondent is not a party to the agreement for sale, it cannot be said.
You are reading from where?
Page number 51.
51.
Lordship, this is basically a compilation from a judgment, lordship, which I wanted to share, lordship.
Which line?
Page number 51. It starts from since, lordship is found it.
Since.
Since.
Huh.
This is a comparison of a judgment for Supreme Court, lordship. Since the respondent is not a party to an agreement for sale, it cannot be said that without his presence, the dispute as to specific performance cannot be determined. Therefore, he is not a necessary party. In paragraph number 14 of the judgment of the Honorable Supreme Court, it has been observed that admittedly, they base their claim on independent title and possession of the contracted property. It is therefore obvious, as noted herein earlier, that in the event the respondent number 1 and 4 to 11 are added and implemented in the suit, the scope of suit of specific performance of contract for sale shall be enlarged from the suit for specific performance to a suit of title and possession, which is not permissible in law. In the case of Vijay Pratap and others versus Sambhu Saran Sinha, reported in 1996 10 SCC 53, this court has taken the same view which is being taken by us in the judgment as discussed above. The court in the decision clearly held that to decide right title and interest in the suit property of a stranger to a contract is beyond the scope of the suit for specific performance of contract, and the same cannot be turned into a regular suit. Therefore, in view of the third party or a stranger to a contract cannot be added and convert a suit of a character into a suit of different character. As noted herein,
since the respondent number 1 and 4 to 11 were not parties in the suit for specific performance of contract for sale of a contracted property, a decree passed in such a suit shall not bind them. And in that case, the respondent number 1 and 4 to 11 would be at liberty either to obstruct execution of order to protect their possession by taking recourse to the relevant provision of the CPC if they are available to them, or to file an independent suit for declaration of title and possession against the appellant or respondent number 3. On the other hand, if the decree is passed in favor of the appellant and the sale deed is executed, the stranger to a contract, being the respondent 1 and 4 to 11, have been sued for taking possession if they are in possession of a decretal property. In paragraph number 17 of the judgment, has been observed that apart, there is another principle which cannot be forgotten. The appellant who has filed the instant suit for specific performance of the contract for sale is dominus litis and cannot be forced to add parties against whom he does not want to fight unless it is a compulsion of the rule of law, as already discussed above. From the above reasons, we are therefore of the view that the respondent number 1 and 4 to 11 are neither necessary parties or proper parties, and therefore they cannot be entitled to be added as a party defendant in the pending suit for specific performance for sale. Now, this was with respect to a judgment which has been referred. From the above discussion, it is clear that the Supreme Court has clearly stated that a stranger to a contract is not a necessary party. I coincide with the decision of the Honorable Supreme Court in Kasturi versus so-and-so as relied upon by the opposite parties. Moreover, as discussed above, the petitioner would be at liberty either to obstruct execution as well as to prove his right title interest by taking recourse to relevant provision of CPC. This is the case. In this case is for specific performance of contract and not a suit for right title and interest over the parties. Since the prayer of the petitioner is to imprint him as a party in this case under Order 1, Rule 10, so-and-so, it is hereby rejected. Now, Lordship, when a specific plea has been taken by me, Lordship, the court would take a blind eye of this, and then the court will see that after the decree is passed, you wait till the decree has been passed, and then you obstruct execution. In my humble submission, that cannot be the rule of law, Lordship. And I am referring to same judgment, Lordship. What has happened in that judgment, Lordship?
Kasturi.
Kasturi, Lordship. That has not been held by this honorable, by this judgment, my. If I am a litigant, Lordship, I am pointing out the mistake to the court, and court will will turn blind eye to me, and he will say that no, don't come now. Wait for execution. And then I can step up and enforce my right. In my humble submission, that cannot be the law.
You missed out the point. You see, what you can do is that you can always file a suit and say that these degrees that agreement is not binding on you.
That I'm acceptable, Lordship. That Lordship fairly submitting, I'm accepting that. Then Lordship, I kindly see this judgment, Lordship.
Yes, I'm there. I'm reading that judgment. I'm halfway through it.
Now, first of all, Lordship, the judgment which has been relied, Lordship, that is not with respect to the same set of facts, Lordship.
A specific performance of contract.
Maybe
This is
Lordship,
also a suit
but
for
the facts,
specific
but the
performance of
facts are
contract.
different, Lordship. Here is not the case where my land has been included, Lordship. Here is a case where an independent right has been formed. So there's two different things, Lordship. Lordship, I kindly see the head note first, Lordship. It will be clear
No,
from that
I'm
note
not,
only, Lordship.
I'm not even having a reading. Show me from the text, I would understand.
Lordship,
Head note is only editorial note.
Lordship. Lordship, I kindly see page. I just read paragraph number 7, Lordship. In our view of bare reading of this provision, namely second
Paragraph?
Paragraph number 7, Lordship.
In our view. In our view.
Lordship, in our
Ah,
view,
ah.
a bare perusal of this provision, namely the second part of Order 1, Rule 10, Sub-Rule 2, CPC, would clearly show that the necessary parties in a suit for specific performance of a contract for sale are the parties to a contract, or if they are dead, their legal representative as also a person who have purchased the contracted property from the vendor. In equity as well as in law, the contract constitutes rights and also regulates the liabilities of the parties. A purchaser is a necessary party, as he would be affected if he had purchased with or without the notice of the contract. But the person who has claimed adversely to the claim of a vendor is, however, not a necessary party. From the above, it is now clear that the two tests are to be satisfied for determining the question who is the necessary party. Tests are there must be a right to some relief against such party in respect of the controversies involved in the proceeding. Number two, no effective decree could be passed in absence of such parties. In my humble submission, Lordship, this does not apply to me, Lordship. And the test number one, I clearly I passed this test, Lordship. No, Lordship, again, Lordship, paragraph number 13, Lordship may kindly see. From the above discussion, it is elucid that necessary parties are those persons in whose absence no decree could be passed by the court, or there must be a right of some relief. Lordship may kindly see some relief, Lordship. Some relief against some parties in respect of the controversies involved in the proceedings, and proper parties are those whose presence before the court would be necessary in order to enable the court effectuously and completely to adjudicate upon and settle all the questions involved in the suit, although no relief in the suit was claimed against that person. In my case, Lordship, my land is under execution, Lordship, through a specific performance, and I am not a necessary party. I am the owner of a land whereby an injunction is passed, a permanent injunction is sought.
Where is the copy of plate?
Lordship Lordship would find at page number 19.
19.
Lordship. There is no whisper in respect to me, Lordship.
You have a copy of Jamavandi with you?
Up to date, Jamavandi is not available with me, Lordship, but I can vouch for it that there has been no further sale, Lordship.
No, no. Do you have a copy?
Lordship,
It may not be up to date, but do you have a copy still?
Lordship, but since it has not been annexed with the, I do not have, Lordship. I can produce it, Lordship.
You get it tomorrow or day after tomorrow?
Lordship, I will not be available for tomorrow day after. On Monday, Lordship, if possible.
Monday. Okay. amongst this schedule at page 23, which of the land you say is yours, contains your part?
In page number 24, Lordship.
24, which one?
There's 2 bighas, Lordship.
There are two bighas.
Yeah, Lordship, first one. A plot
First
of,
one.
Lordship. Lordship can refer to page number 34, Lordship. That is my sale. All the defendants have purchased it through one single sale deed, Lordship. And that is at page number 34. 33, man.
You have only two kata 10 lectures.
Only, Lordship. Out of 2 bighas.
Okay. List on Monday. 9/10/2023, so as to enable the Mr. P. Decker, counsel for the petitioner, to produce a copy of judgment in respect of the supplant.
And suit is proceeding, Lordship. Suit is proceeding, Lordship.
It's okay. Monday.
Lordship.
If you want, we can fix it tomorrow also.
No, Lordship, Monday. Highly okay.
Item 11.
Yes, Mr. Sharma.
May I please, your Lordship? One of this petitioner, the sole defendant, Lordships. Lordship, this matter came up on 15/9/2023, Lordships. The Honorable Court directed to submit the salary slip issued by the official authority, Lordships.
Yes.
Lordships, accordingly, Lordships, I have submitted an affidavit, Lordships, on 28/9/23.
How much is your salary?
Lordship, this my salary, Lordship, that is in page 91, Lordships. My name is Mohammad Ali, Master Role Laborer, Lordships.
91.
Page 91, Lordship. Annexure 11.
91. There is no 91.
Lordship, additional affidavit I have submitted.
It's not there. When did you file it?
I have filed on 28/9.
Shows if you have a copy. I'll be here for further 10 minutes because I have a meeting. If there are others, maybe one or two matters I can take it up within that time. Your salary of 39,900.
Lordships.
Did that affidavit be here? Mr. R. Sharma, counsel for the petitioner, submitted that on 28/9/2023, an additional affidavit has been filed to bring on record the salary statement to project that the net amount, that the gross salary of the petitioner is 43,275, and the net amount of salary after deductions is 39,967. The registry shall tag this track and tag this said affidavit on record. List on Friday. Taken on Friday. Friday. You just inquire in the registry.
Lordships.
Thus. Twelve. Yes,
In this case,
this order has to be stayed, Mr. Sharma. In a execution petition, this what you call demarcation proceeding can't go on.
there is some consent, Lords. There is some consent, Lords. in this case.
What consent?
Proxima, kindly see the order.
Shows that.
Page 34.
34.
Second line. However,
Just
since both the parties agree to the point that the matter of concern is regarding measurement of the decretal length, hence assistance of staff of the circle officer Morimganj will fix the issue. Further assistance of circle officer execution will not prejudice the decree holder.
yes.
There was no consent law. You filed the objection. Since you filed the objection, objection is there on the record. And the learned executing court has specifically made a mention with regard to the fact. And he has no locus standi. Who is he? He is not.
But
the
where is your
judgment
statement
debtor.
that this was without consent? Have you
That
made a
is the ground
statement?
you have taken in the revision also. There is a ground you have taken in the revision also. There was no consent on our part. Yes,
Where is
there is
that? Shows that there was no consent.
no- yes.
If there is no consent, they have to go to the same court for a review, Lordship.
Because since you have filed the objection, there is no reason for this giving consent for that such demarcation of the decretal length. And that issue has already been
No, but
set at rest.
shows that that's the only issue. Shows that.
Also in the pleading, you made a mention with regard to
No, wherever it shows,
Yes.
shows wherever it's stated in this division.
Paragraph number 7, Lordship.
Para 7.
Yes.
No, this will not do. This will not do. You have not stated that this consent was not given to court. You stated that there is no document.
Exactly, Lordship. There is nothing on record which would
No,
say.
no. You see, when you are arguing, you make certain things. The parties are not here to argue.
Then I'll submit my additional affidavit stating that.
You
as
have to
proposed.
say that
Yes,
because you
I'll
see,
submit my additional
it has to be made by the lawyer who is arguing before the court.
Yes.
But he did not give that, what you
consent
call,
affidavit. Yes.
he did not give that consent. Third party can't swear an affidavit on behalf of the lawyer and
Yes,
say
yes,
that
exactly, Lordship. I file an affidavit on behalf of the advocate.
we adjourn it for a week.
13th or 12th, Lordship.
Huh?
12th or 13th. 12th of next week
12th.
or 13th.
Make it 11th. 12, 13 will be the last few days, will be very overburdened. Make it 12th.
12th.
Both sides are duly represented. The on the prayer made by Mr. S.P. Chaudhary, counsel for the petitioner. Matter stands adjourned today based on 12/10/2023.
Enabling to file the affidavit.
I'm not saying anything. But then it will be that
Reflection
the-
is there, Lordship, then it will be easier for me to
No, no, no.
communicate with the concerned.
no, because then it would be as if the affidavit is coming because of the court.
No issue. This issue,
We are not wanting it. We just wanted you to
because
show us.
this particular issue, the demarcation has already been decided by the Honorable Court. Because previously also there was a CRP before the Honorable Court and that was rejected.
No, we'll come to it when,
Yes.
when the matter comes.
Yes.
Item 13.
Yes.
Lordship, by the impugn order.
Where is your list of witness before the trial court?
Lordship,
Where is the list of witness given before the trial court?
list of witness was not filed. Your Lordship.
It's not there. But then why should we interfere with the order?
Lordship, there was a stand in the WS itself, Your Lordship, that the other parties are occupying some land and which we had in West Bengal, Your Lordship. So as it is a partition suit, Your Lordship, and they have only brought on record the suit, the land which is under the jurisdiction of the court and sought partition of the same, excluding the other ancestral properties, Your Lordship, which the other parties already enjoying. The WS
Where is the impugn order?
impugn order is at page 54, Your Lordship.
50?
54,
Oh.
annexure 6. By this order, Your Lordship, two things were done. One, that petition for calling official witness was rejected. Another thing, Your Lordship, there was a question of paying cost, Your Lordship. Cost was imposed on 2 occasions. But the defendant was under the impression that only once cost was imposed and one cost was paid, 1,000 rupees. And the other cost of ₹1,000, which was a precondition for acceptance of the PW3 and DW3 and DW4, was it was not deposited, so it was discarded. Your Lordship. So the defendant, under being under impression that only 1,000 rupees cost has been imposed, has paid once only. Otherwise, DW2 and DW3 affidavits were already filed.
You see, but under 227, we can't correct every error of the trial court. And it is a fact that there was a precondition.
There was a-
Acceptance was conditional. You can't do anything.
To that extent, Your Lordship,
And my lord, that order was passed on the 8th day, my lord. Order 17, rule 3, my lord, that part was already exhausted, my lord, 3 days.
Oh.
DW2 and 3 was filed on the 8th.
No, that's okay. Sometime in 22, that order was there. And we are in now 23. 7-8 months have gone by.
cost was deposited, Your Lordship, only once. The petitioner being under the impression that cost was imposed and she has already paid the cost. But
No, but otherwise in this day when people are complaining about inflation on everything, you have saved money is quite a good thing.
for as prejudice, there should not be any prejudice to either of the parties, Your Lordship. We are ready to pay cost twice the cost that was imposed, Your Lordship. But DW2 and DW3 are very important. We have filed the affidavit long back, Your Lordship. Just acceptance of the
Because you can't do is you know, you are aware of the recent judgments of the Supreme Court.
My lord had last week passed a judgment, my lord, on similar facts, my lord. I'll just go to, my lord, exactly on similar. Para 4, my lord. On Peru, may I read now? Here also, my lord, order 70 rule 3 was completely exhausted and the cost was not paid. And civil adjournments were taken. my lord. It starts from paragraph number 4.
So, Mukherjee, you can't do anything more.
Can it be taken up tomorrow? I will just go through it.
Hmm?
Because there is another aspect also to this order.
Yes.
The question of calling of the official witness.
No, that has to go because it's if it is not in the list of witnesses, you just can't summon anyone, everyone.
Plus, my lord, no specific.
The
detail was
list of
given.
witnesses are to be settled when the at the time of framing of the issues. So if it is not there, the official witness, we can't permit that.
If he is not called through the court, he is called as a DW. In
No,
that
no. You
case,
see, after the Supreme Court judgments, we have altered our, we have amended our High Court rules, the Civil Court rules and orders. Case management rules have been amended. There is no scope actually. If you don't do it, the DW, if the list of witnesses are not there, you can't summon the official witness and get him examined. You can bring him without a notice of the court. There is no bar. But to have a court notice issued on a witness, that would be running contrary to the CPC.
Okay, can it be taken up tomorrow? I'll go through this and I'll take instruction as to whether he wants to call him without the notice of the court. In that case, we can.
Okay, tomorrow it will not come now, day after tomorrow, because the registry will not be entertaining the application. Okay, we'll take this back. We're getting it day after tomorrow. List. Council of the prayer, both sides are represented. List on day after tomorrow. Of the prayer made by Mr. B.J. Mukherjee, counsel for the petitioner.
Then it may come up on Friday.
Which one?
Only one motion gets out. The 40.
Item 14.
Here, my lord, actually in the commercial suit, after 1 year, my lord, the written statement has been accepted, and thereafter my application under order 810 has been dismissed without hearing.
No, but order 7 rule 11. This order 7 rule. Order 9 rule 7.
No, 9-7, my lord, that was against another revision already filed, my lord, that is there.
Okay.
But here, my lord, order 810 application has been rejected without hearing. Because after 1 year, my lord.
No. You see, Mr. Saiwala.
Yes.
Once the trial court allows the application under order 9 rule 7 and permits the other side to file a written statement, your prayer for order 8 rule 10, a decree for non-contesting, that will automatically go. We can't say that.
That was another miscase, my lord, and without hearing me, it was otherwise it will be again, my lord.
No, your hearing is not required. You see, when the court, let us say there is an ex parte decree against you. Order 9 rule 13, under order 9 rule 13, the ex parte decree is vacated. So, if a consequential order is passed in the trial court, can it be said that you are not heard and therefore you are aggrieved? If order 9 rule 13 goes, the ex parte decree goes. If any consequential order is required, court is not required to hear you. Here also order 9 rule 7, the defendant's right to file written statement was taken away. After order 9 rule 7, that was granted to him. So therefore order 8 rule 10 cannot coexist.
That division is already pending, my lord. Order 9 rule 7.
I understand. But we can only close this by saying that if that revision is decided in your favor, then you will have the right to agitate against this. That I record your statement and close it with that liberty. not as a court order, but your prayer will be accepted and liberty be given to you.
I mean,
But Mr. G. N. Savalas, the senior counsel, assisted by Mr. A. Chetia, counsel for the petitioner. Next para. By the impugn order,
the 36,
page,
page 159.
agreed by the impugn order dated 3/6/2023, passed by the London Civil Judge number 3, Kamrup Metro Guwahati in Ms. J case number 403 of 2022, in connection with commercial suit number 24 of 2022, the present application has been filed in Article 227 of the Constitution of India. First, by the impugn order, the learned trial court, without hearing the petitioner, had dismissed the said this case on the ground that it has become infructuous on Ms. J case number 1168 of 2022 being allowed to and thereby permitting the respondent numbers 1 to 6 to contest the suit.
1 and 6.
Huh?
1 and 6.
1 and 1 to 6.
Oh.
1 to 6. To contest the suit.
The respondent here my lord 1 and 2 only.
Huh?
1 and 2. Here they were defendants 1 and 6.
So 1 and 2.
1 and 2.
No, 1 and 6.
Defendant 1 and 6.
Okay,
And
not
here
1 to
was
6. Okay. The respondent numbers 1 and 2. First stop. Next para. On a query of the court regarding disposal of Ms. J case number 1168 of 2022, the Honest Senior Counsel for the petitioner has submitted that in respect of the said of the order passed in the said Ms. J case number 1168 of 2022, separate revision has been filed
297 of
being CRP
297 of
297 of 2023.
IO.
CRP IO. Okay. First off, on a second query of the court, that if order 9 to 7 application is allowed, the CPC is allowed, the application under order 8 rule 10 CPC would be counterproductive. The on the said query, the Honest Senior Counsel, the petitioner has submitted that he will be permitted to withdraw this petition to assail the said order, depending on the outcome of the of CRPIO.
We can file a fresh petition under order.
Huh?
We can file fresh petition under order.
No, that liberty we can't give without hearing the other side. To re-agitate the challenge based on the decision in CRPIO to CRPIO to 200
297.
297 of 2023. First of all, the prayer is allowed with liberty as prayed for. This revision stands closed. Yes.
We had an election petition that order 14 rule 2 sub rule 2. My part of the argument was over. Mr. Das' argument was supposed to be resumed today. I am told by my colleague that he has written for the matter. So if the lordship permits on the next day, since I have already and I have gone through the records, I will file a written argument before the lordship so that at least it can be.
You take it up on Monday then?
Monday.
My lord,
newly engaged by the election petitioner. And the whole of them is served.
You are appearing the
Election
matter.
petitioner.
Now, in case of Mr. Das.
No, yes.
Okay. Both sides are duly represented.
Order dated my lord.
Mr. Mr. Andy Bhuya, current counsel, appearing for the election petitioner, has submitted that he has appeared by filing a wakalatnama today.
Yes, sir.
By filing give a date. Is on 3/10/2023, which is not on record. So the registry shall tag this said wakalatnama on record this on the next week, Monday, 9/10/2023. 9/10.
My lord, I would like to submit that in one interim application civil 1982/2023 by the order dated 22/8/23, Your Honor. The election is given chance to file objection. Your Honor. So my humble submission before your lordship to give a chance to filing objection. Your Honor. In the application under.
Mr. Bhuya, the tragedy is that in a election petition, whatever you have to say, you'll have to file an application and then make that prayer. It's just like a
In Azhar Hussain case.
By the order dated.
no. You see, it goes like a suit. Everything you have to say, you'll have to file a petition. On the next day, you file a petition. We can't say anything more.
In Azhar Hussain, 26 years back, it was said, election petition is just like a sword of Damocles kept hanging on the head of a returned candidate. Now,
I have to rise because Mrs.
On the strength of the order, I.
No, Mrs. Chakravarti will fix the matter on some other day because I have a meeting at. It has already started at 4:30. I am overshooting it.
it's
So
coming up on 9.
your matter will come. Her matter will come Friday. Court master will take care of it. I have a meeting I have to attend.
Item number 39.
Court master.